On the record, in the matter of the people of the state of Michigan versus Angelo Garza, file number 23-01174. Council appearance.
Jeff Reynolds on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Angelo Garza.
Mr. Garza, can you hear me?
Yes, Your Honor.
Please, the date and the time that's set for sentencing. I do have a pre-sentence report stated, prepared on 10/10/2023. Did you get a copy of that, Mr. Lee?
I did, Your Honor.
Have you reviewed that with your client?
I have.
Are we making any updates, corrections, or deletions to the report?
We don't have any updates, deletions, or corrections, Your Honor.
Make allocution.
Thank you, Your Honor. We asked the court to consider that Mr. Garza has taken responsibility in this matter. We asked the court to follow the recommendations of the pre-sentence investigation report, including a suspended sentence, 12 months probation, Zoom reporting, outpatient substance abuse, and random alcohol and drug testing, as well as obtain and maintain employment. Mr. Garza admits that he has had some issues with alcohol and is looking forward to participating in the outpatient substance abuse program. He has a friend that he intends to contact as soon as he is released to join his vinyl flooring crew, in which he has experience and will be able to be employed that way. He also will be living with his stepmother, who will provide a sound support structure for him. So we asked the court to consider the recommendations of the pre-sentence investigation report.
Did your client wish to make any statement for himself?
Do you wish to make any statements, Mr. Garza?
No, Your Honor. Everything sounds about right.
Okay, thank you. I reviewed the pre-sentence report and the recommendation. Violence backwards. Recommendation is that the defendant should be placed on the term of probation. 12 months is recommended with intensive outpatient substance abuse treatment and random alcohol drug testing. And that's due to the finding that he has, as you indicated, had some issues with drugs and alcohol. He does have an extensive criminal history. He also has a history of failing to appear in court. So the court does have concerns about his willingness to participate in a term of probation. What I don't want is to put you on probation and I got to keep tracking you down.
Your Honor, I did complete parole recently.
Yeah, I had to remand you on a bond just to get the PSI done. So you don't really follow court orders too well. Why do you believe that you would be successful in a term of probation?
Yes, Your Honor. I just missed court one time.
You said yes. My question was, why do you think that you'll be successful on a term of probation? You said yes. You just missed court
yes,
one
Your Honor.
time.
I have completed parole recently, within the last couple of years, And I only did miss court one time. I do believe I can be successful on probation and completing outpatient. I'm ready to start working. I have worked before. I'm with Vinyl Crew, doing flooring with my friend, and I'm hoping I can get my spot back on that crew. I'm ready to do outpatient. I believe I'll be successful, Your Honor.
I'm going to adopt the recommendation and give you a chance on probation. Your probation terms will be as follows. It's 12 months probation. While on probation, you're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or dangerous weapon of any kind. You're not to use, purchase, or possess alcohol, marijuana, or a controlled substance that you do not have a prescription for, okay?
Yes, Your Honor.
You're gonna be required to submit to random preliminary breath test and urinalysis testing. You have to pay the fee for that, okay?
Yes, Your Honor.
I'm gonna also order that you not be at any bars or nightclubs. You need to participate in intensive outpatient treatment and provide verification to probation. You need to maintain employment and provide verification to probation. Do you have any questions so far?
No, Your Honor.
Is 74 days, or do we need to update that? Credit.
74 days as of the day of the report.
365 days Ingham County Jail. I'll suspend. I'm gonna give you credit for 74 days. I'll suspend the balance upon successful completion of their 12-month term of probation. Also on probation, there's a $30 per month oversight fee that you're responsible for. So for 12 months, that will amount to $360. There's a $75 crime victim rights fee that you're responsible for, as well as a $50 state minimum cost that you're responsible for. I'll waive discretionary fines and costs at this time. There was no restitution in this, correct?
Correct.
Okay. When did he enter a plea? When did he enter a plea? I don't know anything about it. June 15th. That's not what I don't have anything in June 15th. Someone else took a plea for him because it wasn't me. Did Flores take his plea? This is on my handwriting. Why did Judge Flores take his plea? Oh, he did a PCC. Did he plea at PCC?
That's what our notes indicate.
Judge
Your Honor.
Flores took his plea. Did he waive his right to be sentenced by the judge who accepted his plea? Because I didn't take his plea.
Well, that's a good question. I don't, let me see if I have a note on that.
PCC was Tim Flores. He took a plea at PCC. That's why I don't see it. I don't see it up for me.
Client does not object to being sentenced by a different judge than the one who took the plea.
Okay, sounds good. Very good. Okay, so again, I'll waive discretionary fines and costs. So your total fines and costs is $360 plus the statutory fines, which will amount to $485, but you'll make monthly payments on that, okay? Or you'll be able to make monthly payments. So that's about $40 a month, okay, sir?
Thank you, Your Honor.
No problem. Lastly, there's an advice of rights as to probation. It says you have been sentenced to a term of probation in the 54A District Court. The probation conditions have been individually tailored and are specific to address your assessed risks and needs. Except for domestic violence, criminal sex crime, and stalking offenses, or an offense where the defense of guilty but mentally ill was asserted, you may be eligible for early discharge from probation. You have the following rights. You have the right to request early discharge from probation once you completed half the original probation term ordered by the judge. Your probation officer may but is not required to file a notice with the judge once you become eligible for early discharge. The probation officer must then serve a copy of that notice on the prosecuting attorney. The prosecuting attorney has 14 days from receipt of that notice to file any written objections. You may make your own request for early discharge once you become eligible, and you would become eligible once you've completed all probation programming and have not violated probation within 3 months prior to that request. You must send a copy of your request for early discharge to the prosecuting attorney and to your probation officer. The prosecuting attorney has 14 days after receipt of your notice to file any written objections. If a hearing is scheduled to address your request, you have the right to hire an attorney. You do not have a right to court-appointed counsel. Lastly, you can make that request by using the MC 512 form, which is on the court website, or you can get that from your probation officer. Do you have any questions?
No, Your Honor. Thank you, Your Honor.
Okay. Give me your address that you're going to reside at.
830 Banghart, Lansing, Michigan, 48906.
And your phone number?
517-894-9492.
Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing for the defense, thank you.
Okay, once you release, sir, you need to check in with probation within 48 hours, okay?
Yes, Your Honor.
You're all set.
Thank you, Your Honor.
You're welcome. On the record in the matter of the people of the state of Michigan versus Trina Kuthin, file number 23-02351, counsel appearance.
Jeff Braddock's on behalf of people.
Morning, Your Honor. Attorney Derek Eshel on behalf of Mrs. Trina. She's appearing by video and I'm here in the courtroom.
Oh, okay, Ms. Kuthin, can you unmute your device?
Ms. Trina, unmute yourself, please.
It's possible she didn't hear, since there's a party going on in the hallway. Or in the courtroom across the hall. Ms. Kuthin, unmute your device, please. Can you hear me?
Yes, I can hear you.
Okay, thank you. Today was the date and the time that was set for a sentencing. I do have a pre-sentence report and recommendation. It was prepared on September 29th. Did you get a copy of that?
Yes, I did, Your Honor.
You need to make corrections, updates, or deletions.
Your Honor, I've reviewed it with Ms. Kuthin and there are no additions or deletions or corrections she would like to make. We did file a petition for 7694A as well. I don't know if the court received that.
I believe it should be in the file. We did receive it.
Followed around September 25th.
We did receive it.
Thank
I
you,
don't
Your
have
Honor.
any objections from the prosecution. Do I?
No, no objection.
Thank you. You can make allocution.
Thank you, Your Honor. Your Honor, I had the opportunity to review the pre-sentence report recommendations with Ms. Kuthin. Your Honor, since I took representation of this case, was assigned this case, Mrs. Kuthin's always taken responsibility for her actions. She knows at the time that she overreacted in regards to what was occurring with her and Mr. Ash. when I reviewed the pre-sentence report with the page 1, the next to last paragraph under her assessment and risk scoring, that pretty much summarized my experience with her. She takes responsibility for her actions, understands she should have handled the situation differently, recognizes relationships unhealthy and toxic for both, and that her actions were unacceptable, and she needs to work on trying to handle her emotions and reactions better. Your Honor, I would ask the court to follow the recommendation, grant 7694A, the term of probation and conditions. She would leave up to the court's discretion. She would ask the court to consider limiting, waiving, or forgiving any fines, fees, or costs the court would assess. She is on public assistance and receives food stamps of $281 a month and Medicaid. She works a part-time job of around 23 hours a week, earning roughly $1,200 to $1,400 a month, and her living expenses are about $1,000 a month. I think the report does show some concern in her ability to be able to meet her obligations of probation, financial obligations. So she would ask the court to consider limiting or waiving that to whatever funds she can try to use toward any treatment or testing the court may impose against her. Whatever the court does, it says she would ask the court to allow her to pay it over the term of probation. Thank you, Your Honor.
No problem. Did you want to make a statement?
Yesterday when I talked to her, she said she would, but Ms. Guzman, would you like to make a statement to the court, or do you not want to talk now?
I believe that everything in the PSI report is truthful, intact, and I'm not going to deviate from it.
I reviewed the pre-sentence report. I've also reviewed the your criminal history. I'm going to be quite frank. I'm concerned about the number of alcohol-related convictions you have, and if that's been properly addressed. I see in a report where you supposedly reported to the probation officer that you had not, or you denied use of alcohol in over a year. But again, we have a disorderly drunk conviction from March of this year, the date of incident being last November.
That's correct, Your Honor.
Okay, so is the statement that you hadn't used alcohol in over a year still accurate?
I'm sorry?
So was the statement, did you make that statement to the probation department that you had not used alcohol in over a year?
I think I did. Don't really remember. I probably
Okay.
did.
Did you forget about the disorderly drunk from November when you made that statement?
No, not really. I really didn't even think about it, to be honest with you. I didn't think that it would have a bearing on this case at all, being that it was in a different.
We're not. Well, I'm not asking if you thought about whether or not it had a bearing on this. The question was about you using alcohol, and you said you hadn't used it in over a year. Is that the truth?
At that time, I did use alcohol. Yes, I did.
Okay, so it's not been a year. And then when is the last time you engaged in the use of alcohol?
Actually after that incident.
Okay, and so have you been in any programming to address that?
I did actually. I did go to TRICAP. Let's see, that was February.
When did you go to TRICAP?
That was from February through May of this year.
Okay.
And alcohol was somewhat addressed. I'm trying to think of the programming that they had. Emotional things, those were addressed. I did go through anger management. That's what I'm trying to say. I did go through an anger management class with them. The programming, whatever programming that they had at that time, I did successfully complete that.
Okay, and then you also indicated that you didn't want to be on probation.
I did.
Is that true? Well, that's what the report says. It says that Ms. Kuthin advised she does not want to be on probation.
I don't remember saying that, but.
Okay, so that's not your position?
I know that there is gonna be some type of repercussions of this. If probation is the thing that I need to do, that I will do that. I have successfully completed probation when I was on probation.
Okay, well, the request is for you to be placed on, or the petition that I received from your attorney was for you to be granted a term of sentencing under MCL 769.4A, which is a special status, which means you would need to be on probation. You understand that?
Yes, I do.
Okay, you don't have problems with following the terms and conditions of probation?
No,
Okay, I'm going to grant the petition. I'm going to adopt the recommendation. The sentence will be as follows. 9 months probation. We'll report via Zoom. While on probation, you're not to engage in any assaultive or threatening behavior. You're not to have contact with the victim, that's Fred Ash. That's no contact directly or indirectly. Do you understand that?
yes, ma'am.
You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to possess alcohol or use alcohol, marijuana, or of any other controlled substance that you don't have a valid prescription for. Do you understand that?
Yes, I do.
Okay, you're gonna be required to submit to random preliminary breath testing and urinalysis testing. You have to pay the fee for that. You're not to be at any bars or any nightclubs. Do you understand that?
Yes,
Not gonna order any programming at this time because you did successfully, I presume, complete TRICAT within this year. And the hope is that you don't need any more outpatient treatment, but if that becomes a problem, we'll address that during this time of probation, okay?
okay,
While on probation, there's a $30 per month oversight fee that you're responsible for. Per statute, I need to assess a $75 crime victim rights fee plus a $50 state minimum cost. Total fines and costs will amount to $395, but you'll get to make monthly payments on that, which is about $43, okay, a month.
okay.
Do you have any questions so far?
No, I do not.
Okay, so again, I'm
Oh,
going
I
to grant
do.
769.
Now, the
Yes, ma'am.
$43, is that in conjunction with the $30 also?
Does this include what?
The $43 per month, is that in conjunction with the $30 that I have to pay per month for the probation?
That's correct.
So is that gonna be 73 or is it 43?
Nope, that includes that. So
Oh,
$30 per month for 9 months amounts to $270. And then you have a $75 crime victim rights plea plus a $50 state minimum cost. So the total of your fines and costs is $395. So that's what if you pay monthly, it'll be about $43 a month. And then
Okay.
maybe $44 a month because there's a little bit of change there. And then that does not include, however, the cost associated with doing your drops, okay?
okay,
Do you have any other questions about that?
no,
Okay, lastly, there's an advice of rights as to probation, and it states that you've been placed on a term of probation here at the 54A District Court. Your terms and conditions were individually tailored to specifically address your assessed risks and needs, except for domestic violence, criminal sex crimes, stalking offenses, or offense where the defense of guilty but mentally ill was asserted, you may be eligible for early discharge. You are on probation for domestic violence, so you would not be eligible under this statute to request early discharge from probation once you've completed half the original term. Do you understand that?
No, so I cannot ask for early release from probation?
You're not eligible under this statute to request early discharge from probation because you are on probation for domestic violence.
Okay, so I have to do the whole 9 months.
That's correct.
Okay.
Okay. Do you have any other questions at this time about your probation terms and conditions?
No, ma'am.
Okay. Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor. Thank you.
Okay, and Ms. Coogan, can I have an updated address for you?
2920 South Washington Avenue, apartment 303, Lansing, Michigan, 48910.
What apartment is that again?
303.
Okay. You're all set. You'll check in with probation within 48 hours. You can go over my judgment of sentence, okay?
Thank you, ma'am.
Thank you. You're all set.
Thank you.
You need me? For this or something else? Oh, okay. Molly, did you want us to bring Mr. Lopez here?
Yes, Your Honor.
Okay. You can bring Mr. Lopez and Mr. Jackson. I did see Mr. Samuel, but he is not in here now.
Yes.
Sit right there until we just close the case.
Okay. On the record in the matter of the people of the state of Michigan versus Joshua Greg Williams. File number is 23-02207. Council appearance.
Stage Councilman on behalf of the people.
Morning, Your Honor. Attorney Derek Tetris, public defender, on behalf of Mr. Williams. Mr. Williams is right here standing to my left.
Good morning, how are you? Very good. She's blessed too. Okay, let's see. Today is the date and the time that's set for preliminary examination. We did waive 21 days back on September 8th. How are we proceeding today?
Your Honor, we are not prepared to proceed at this time. The victim has not appeared for court today, so I would be without prejudice.
I would not object to that, Your Honor.
Okay, you had contact with the victim at all?
We have, but it kind of fell off the last week, so she is not here today. She was served.
Dismissal without prejudice means that they have the right to reissue the charge against you. Do you understand that? Okay. Do you have any questions at this time? The motion to dismiss without prejudice is granted. We'll get you a copy of that in just a moment, okay?
Thank you, Your Honor. So just have a seat back on the bench where you're at, okay? Mr. Williams, not right outside where you're at.
Man. So, I didn't get to schedule. Who scheduled that? I didn't get to. This was a civil day, but I said, since we had to reset a bunch of things. Did we tell the attorney not to go? No. Well, we didn't appear. So, yes, I'll say no. Let me do this. Real quick. They filed an objection to installment. Okay, we're on the record in the matter of Credit Acceptance Corp. Versus Vanessa Smith, also known as Vanessa Lowry, file number 17-04437 GCE. Are you Miss Vanessa Smith? Can you hear me, ma'am? Maybe she can't hear me. Is she frozen? She's frozen.
Yeah, I know. Plan is running.
Okay, well, she's gone. Okay, well, the matter was scheduled for a hearing for an objection to installment payments, scheduled for today at 9 o'clock. Ms. Smith appeared to be there via Zoom. I think she's trying to log back in. Ms. Smith, can you hear me?
Yes, but it's Miss Lowry.
Oh, okay, okay, but it was Ms. Smith on this file?
Yes.
Okay, thank you. So we have to go by whatever's in this file. I recognize your name is now Lowry, but this file was under, and there's a judgment against Vanessa Smith on this one. But I do see your name listed here in quotation as Miss Lowry. So let's see. Today was the date that was set for an objection to installment payment hearing. You requested an installment payment order? And
Yes.
the counsel for the plaintiff did object. They said that you defaulted on this matter, meaning you didn't appear in court to defend the lawsuit back on May 30th, 2018, in the amount of $14,786.51 was ordered as a judgment against you. You currently owe, due to interest, $17,342. You filed a motion for installment payments requesting to pay $50 per month. Do you know how long it will take you to pay off $17,000 if you made $50 per month payments?
A long time.
Indeed, are you employed?
Yes.
Where are you employed?
Happy Elephant Daycare.
What do you do there?
I'm the lead teacher in the toddler classroom.
Okay, your average income is about $1,800 a month. Can you hear me?
Yes.
Did you hear my question?
It ranges from different amounts because my hours differ each week.
Okay, so, but this is the average, is what you put?
Yeah.
Okay, and then you have rent, you have utilities. Right there, you're already at $1,100 per month. It says that you have a vehicle, but you don't owe any money on that vehicle? No? Says you owe $20,000.
Yeah.
That's correct? How
Our
much is your
payment,
car note?
it's, let me see. The payment is 452, and then the insurance that I have to pay to the company is 108. There's also another insurance payment that I have to pay that is $206.
It's 108, and then you have to pay something for $206.
I pay 206 to LA insurance, I believe it is, and then I have to pay the 108 to the car company to make it full coverage.
So that's a total of about $314 for
Yeah.
insurances. I don't know, man, because you say your average per month is 1,800, and you just gave me expenses that are above that. You haven't eaten or put any gas in your car. So you're not telling me all of your expenses and all of your money.
I'm married, so I mean, my husband makes money as well, but
Okay, so the rent, he's paying that or you're paying that?
I am.
Okay, that's your portion? The $600, or is that your total rent?
The total rent.
Okay, and then utilities, $500. You all split that?
Yes, I take consumers, and he does board, water, and light.
Okay, so you don't pay, because you put, I pay $500 in utilities. You don't pay $500 in utilities out of your pocket, then, do you?
The consumers is 400 alone right now, but
Okay, okay. And so what other bills are you paying out of your pocket?
my cell phone,
Which is what?
$60 a month.
Right now, we're at 1926 in expenses. You told me you bring home about 1,800. So you got access to some money. Where's your husband work?
At Homewood Suites Hotel.
What did you do there?
Head of,
I couldn't hear you.
head of maintenance.
Okay. Do you have any other outstanding debts or judgments pending?
Not that I know of, no.
Okay. And can you make a payment of $100 a month?
Yes.
Okay, I'll grant your request for installment payment order. That will keep you from getting a garnishment so long as you make those payments. So no garnishment will issue as long as you're making those payments. I'll change your paperwork to note that you'll be making a payment of $100 every month, beginning November 10th, okay?
Okay.
Have any questions at this time?
Do I just make the payment to the same company that is on the court
Make
paper?
payment according to this order, but you'll get a copy in the mail, ma'am, but you need to make the payments to the plaintiff's attorney, okay?
Okay.
And their contact information will be listed on this order. If you have questions about that, you can call our civil clerk's office, okay?
Thank you.
You're all set for today, ma'am. Thank you.
Thank you.
You're close.
Just one more. I have
All rise.
Back on the record.
Okay. Where did we lose the transcription? I know the last thing I asked was that distance closed? The answer was yes, before we had to stop. Did the transcription cut out before then? Okay. I can easily go back to these questions.
Last thing I saw was when she was talking about Project 9, and he pointed it at her and threatened her. You know, what was his last question? It was about the pocket, did it escalate? He doesn't tell you exactly what he said? That's what I'm saying. It didn't, the last question that he asked is not on the record.
That's what I
Okay,
figured.
very good.
I figured there was some lag time in between it actually crashing. So I can go back.
That's fine.
Are we good?
Yep.
Oh, not you. Her.
Yeah.
Okay. So, officer, when you're speaking with Ms. Salas, did she tell you if it escalated?
She did,
And is that when a knife came into play?
yes.
What can you tell me about what she told you about him, about the knife coming in? I know we already asked this, but we have to again.
When he pulled the knife out of his pocket, he pointed at her and threatened to kill her and slash her face.
Okay. And then did she run away?
She did,
You said before they were 20 feet apart when they were yelling at each other, just yelling at her, wanting to stay at the place. Did that distance close?
yes, it closed to about 3 feet,
Okay. Was he still chasing her with the knife?
yes.
Did she tell you if she was afraid of being stabbed?
She said she was feared for her life because this has happened in the past.
Did Maria tell you she was able to get away from Mr. Lopez?
She did.
Where was she able to get away to?
She was able to run inside the main entrance to the building and close the door behind her.
Now, was Mr. Lopez there at that venue when you were speaking with Ms. Salas?
No,
Did she see where he went?
yes.
And what did she tell you about that?
She told me that once she retreated back up to her apartment, she heard him yelling downstairs. She looked out her window, first observed him throwing rocks towards the apartment, and then him taking off on foot, running towards I believe it was an Impala, and getting in a vehicle with a female driver.
And did she know who that driver was?
Yes.
And who was that driver?
I'd have to refer to the name real quick.
Would looking at a copy report help refresh your memory for that?
Yeah.
fact? If the witness could be allowed to review her report to refresh recollection?
Yes.
Officer Mars, please don't read it aloud. Please read your report to yourself silently. When you're done, turn it back over. Let me know that you're all set, and I'll ask you the question again. All set?
Yep.
Okay. Now, did that help refresh your memory?
Yes,
What was the name of the driver?
Stephanie Raw.
Did you end up speaking with Stephanie Ron?
No,
Do you know if other officers spoke with Stephanie Ron?
yes.
Now, you said that Ms. Salas told you the name of the person, protector, Juan Lopez, that they used to date, correct?
Mhm.
Is that a yes?
Yes,
Now, did she give you any other information about him?
yes.
And what kind of information did she give?
That they have a past history of him assaulting her, but she had never reported it.
Until the other case with the P53?
Yes,
You were able to locate that P53, correct?
yes,
Using that and the information she gave you, were you able to locate someone matching that information in your law enforcement systems?
yes.
And what system was that?
Arlene Davis,
What's that stand for?
law enforcement, the exact term, I don't recollect.
Okay, but it's the law enforcement information systems?
Yes,
And is there photographs of those systems?
yes,
Now, did a photograph come up?
yes, sir,
And do you see someone in the courtroom matching that photograph?
yes.
Could you please point out where that person is located, maybe something about them, differentiate them from the other people around them?
He's over there wearing a blue jumpsuit.
If that could reflect that she has pointed to and identified the defendant in this matter?
Any objection to identification?
No, Your Honor.
Identification is noted for purposes of
Thank you.
preliminary.
Your Honor, at this time, people have no further questions for Officer Myers.
Cross-examination.
Your Honor. Morning, officer.
Good morning.
So you testified that you were dispatched to the Richwood address on August 19th, correct?
Yes,
And was this in the morning? All right. Do you recall it being, you said, or recall it being around 8:30?
yes, ma'am.
Okay. And when you arrived, was Miss Solis in her apartment?
No, she showed up. I believe, I don't remember if she was in her apartment or if she was downstairs when we made contact.
Okay. And you testified that she told you that there was a protective order on a case in circuit court.
Yes,
And she told you that there was a tether order in that case, right?
Yeah.
And did you contact the tether company?
I didn't.
All right, but it's your understanding that other Lansing Police Department officers did contact the tether company,
Yes, ma'am.
and they contacted the tether company to locate Mr. Lopez, correct?
Yes.
All right, was there any information obtained from the tether company in regards to his whereabouts for that day or morning?
Objection at this point, it's hearsay.
I don't believe it's hearsay. I'm not asking for if what information they got. I'm just asking if they got it.
Okay. Well, you could ask if this officer got that information, I suppose.
Okay. Yes, I will. Officer Myers, did you obtain from JSG any of the tether information regarding Mr. Lopez's whereabouts that morning?
No.
Okay. Also, is it your understanding that section of Richwood is monitored by Lansing Police Department cameras?
I don't know.
Okay. Do you know if any information from those cameras was obtained to corroborate Mr. Solis's statements?
I didn't collect any.
All right. And was there any other witnesses when you arrived on scene to the allegations?
No.
All right. Did you do any neighborhood canvassing to see if anyone had witnessed this event or at the time at which it was alleged to occur?
Don't recall.
And also you testified that Ms. Solis had identified the driver in the car that Mr. Lopez entered.
Yes.
And did she say how she knew this woman?
Past history with him.
Did you look in, or did you know if any information had been obtained from the tether company in regards to the exclusion zone set for the tether?
What was the question?
I'll because I was a little disjointed, I'll just go back and say it and ask it again.
Okay, thank you.
Officer Myers, did you obtain any information from the tether company in regards to the exclusion zone on Mr. Lopez's tether?
Objection, relevance, and also I think asked and answered, as she said that she did not contact the tether company. Further, I don't think it'd be relevant to today's proceeding, but it would to the circuit court P53.
Ask and answer.
Well, no, I'll ask a different way. Did you get alerted from the tether company that there was an entrance into the exclusion zone?
Objection, asked and answered. She said she had no contact with the tether company.
Well, no, she said I asked if she had contacted the tether company. I didn't ask if the tether company had alerted her.
Okay, good answer.
Do you want me to repeat the question? Did you receive any alerts from the tether company that Mr. Lopez had violated the exclusion zones? I think that was the question.
And at this point, I'm going to object to relevance again. It's not relevant to today's proceeding. It would be to a P53.
Well, I think it's very relevant if there is an exclusion zone in place for that address.
I think it goes to credibility. I'll overrule the objection. You can answer.
No.
And did you ever, and of course Mr. Lopez wasn't on scene when you arrived, correct?
Correct.
And did you ever did you personally locate Mr. Lopez?
No.
Or get a statement from Mr. Lopez?
No.
You reported that Ms. Solis was able to get into her apartment building and close the door, correct?
Yes,
Did she say whether Mr. Lopez followed her in the building?
he did not.
Why not?
She was able to close the door of the apartment building itself to get away from him originally.
Was the door locked?
No,
So is there any way, was there anything to prevent Mr. Lopez from entering the building as well?
not that I know of.
But it's your understanding from Ms. Solis that he did not enter the building?
Correct.
All right. And then you testified that she said that he was throwing rocks at the building?
Yes,
Did you see rocks around the building when you were talking to her?
no,
All right, and did you see any damage to the building when you were talking to her? Did you look for any broken windows or damage to the side of the building?
there was no damage to that.
And then when you talked to Ms. Solis, did you observe any injuries on her?
No,
Okay. Your Honor, no further questions.
Briefly. Officer Myers, you located the P53 that was in place, correct?
yes,
Was there any specific address for an exclusion zone listed on that P53?
no,
So there would be no exclusion zone for the tether to go off for?
correct.
All right. Further, did Ms. Salas tell you that she held on to the door to prevent Mr. Lopez from entering?
Yes, she did.
Did she say how long she held on to the door for?
I believe a couple minutes.
Okay. Specifically to stop him from entering.
Correct.
So that was what was preventing him from entering the residence for that period of time, correct?
That was the downstairs main door to the building. And after she held on it for a period of a few minutes, at some point she felt that she could run up to her apartment, and at that time she ran into her apartment and locked her door.
Thank you. People, no further questions.
This witness may excuse.
You may.
Thank you, Officer Myers. Call your next witness.
People, no further witnesses, Your Honor.
Is the defense calling any witnesses?
Your Honor, no, we do not have any witnesses.
Okay, now you can proceed to argument.
Your Honor, I believe that the sufficient factual basis has been made for purposes of probable cause standard to bind over on count 1, felonious assault, and count 2, domestic violence. I would ask that you bind over as charged.
Thank you, Your Honor. The prosecutor is trying to bring in Ms. Solis' statements under 27C. Obviously, they have to be a statement that narrates the infliction or threat of violence that involves domestic violence made at or near the time of the infliction or threat under circumstances that would indicate trustworthiness made to a law enforcement officer. Your Honor, I believe that defense would argue that these statements should not be admissible. As such, they are not under circumstances that would indicate trustworthiness. There was no evidence corroborating Mrs. Solis' statement. You heard the officer testify that she didn't see any damage to the building. She didn't see any injuries to Ms. Solis. There was no other witnesses to this. There was no other evidence provided, whether that be surveillance or other witnesses to it. There was no, they didn't obtain from JSG. Mr. Lopez was on a tether at the moment. They could easily have discovered information that corroborated or exculpate or is exculpatory to Mr. Lopez, and they haven't provided that evidence to defense her today. So it's not corroborated by anything else. I believe that there is a bias or motive for lying. Ms. Solis knows that Mr. Lopez was picked up by his fiance that day. He saw her, he saw him, but there's no indication that he was violating an exclusion zone when he did this. The the policy for a tether on exclusion zone is, oh, I believe this court, it's almost judicial notice of it. For a JSG.
Yes.
Okay, all right. Well, all right, it's my understanding that JSG, if there was an exclusion zone, would have contacted the alleged victim to put an address on it.
You're talking about exclusion zone, you're talking about from another matter, the bond condition, or another matter?
Yes,
Okay, so what you're saying is that because there's no evidence that he violated an exclusion zone on a GPS tether from another file, that we don't have probable cause in this matter, because I don't even know anything about this other file. I don't even know, even if there, let's say there was an exclusion zone, I'm sure a bond condition, even if it was there, was that you can't have contact directly or indirectly, period. Regardless of an exclusion zone. The other thing is that matter is not before us here. The issue I'm dealing with is not whether or not he violated an exclusion zone, even if he didn't have another matter pending where there's a bond currently requiring a GPS tether and exclusion zone. The allegation here is that he made an assault and that there was domestic violence for defense. That's the allegation here.
Your Honor, and it's only being presented to show that there is potentially corroborating evidence that is not being presented here today. So there isn't anything to corroborate Mrs. Solis's statements, and these are just potential things that could have corroborated her statement that isn't here today. Besides that, Your Honor, again, going to, I believe that there is clearly a pending litigation in this matter, that Ms. Solis was actively, there was pending litigation. We understand that from Ms. Solis's testimony, from the statements from Ms. Solis. So there is also, I believe, a motive for lying or a bias in this matter, considering that she already knew that that other case was there and that there was a protective order, and that she saw if she saw the defendant that morning, and she also is saying that she saw him with the other woman. I believe that there is clear, and I think that there is bias in this case, and a motive from potentially from Ms. Solis. I believe that there's nothing to corroborate her evidence. There is pending litigation that she could have contemplated. So I don't believe the statements here were given under circumstances that would indicate that it was trustworthiness. And so that we would ask that those statements be excluded and that this case be dismissed. Thank you.
Steve, re-argument.
Yeah. She was scared, crying, and afraid for her life, and incredibly upset when talking with the officers. The defendant had a TA-53 in place for a different time that he attacked her. Those are circumstances that indicate trustworthiness, Your Honor. The defense's argument that she can't be trusted because there's pending litigation, with that litigation being the fact that he is on bond for attacking her in other felony assault charges, that doesn't make her statements less credible because he's already facing charges for attacking her. That lends credibility to these statements. To say otherwise would mean that because he's victimized her already means that she cannot be trusted as a victim when he does it again, which is bonkers. There are circumstances that indicate trustworthiness here. I would ask that you bind over as requested. These circumstances, the requirements for 27C, have very clearly been met in this matter.
Thank you. The defense counsel made a standing objection to entry of testimony at the beginning of the examination. Testimony being brought in under 768.27C. That objection is noted, obviously overruled, because as the law provides now, this is a valid statute whereby hearsay evidence may be submitted in a domestic violence or a matter involving domestic violence. We had testimony today because the alleged victim in this matter, Maria Solis, did not appear. We had testimony from Officer Stacy Myers from the Lansing Police Department, who stated that on or about August 19, 2023, she reported to the area of 5901 Richwood Street, City of Lansing, Ingham County, State of Michigan, making venue in this court appropriate. She indicated that she spoke with Ms. Maria Solis, the alleged victim in this matter, and she proceeded to narrate or report an incident that had recently occurred. She indicated that when questioned, the officer indicated that the demeanor of the alleged victim was that she was upset, she was crying, and she was seemed afraid, or stated she was afraid for her life. She seemed afraid is what the officer stated her demeanor was. And the officer testified that the victim narrated a assault by a person by the name of Juan Lopez, that the victim provided information, including that the defendant had, or the suspect had, other pending cases. There was an active PA 53 protecting her, and that there were other bond conditions, including a GPS tether and a prior assault against her and I believe her new boyfriend. She indicated that she went to go to the mailbox and that her mailbox was across the street, is that she was leaving the mailbox, and when she turned around from the mailbox, the defendant allegedly, or the person identified in this court as the defendant, popped out from a building that was next, from the side of the building next to where the victim was, pulled out. There was an argument or back and forth that ensued. It escalated. The defendant allegedly pulled out a pocket knife, pointed it at her, threatening to kill her and slash her face. The victim allegedly ran away. It sounded like at the beginning of their interaction, they were approximately 20 feet away, but as things escalated, that distance closed into about 3 feet away. The victim again reported being in fear for her life and stated that this has happened to her in the past. She ran into the main entrance of her building. When questioned on redirect, officer shared that the victim had to hold the door closed to prevent the defendant from following her. She was able to look out of the window when she was back in her apartment, and she indicated that she saw the defendant throwing rocks at the building and then getting into an Impala vehicle and leaving with another individual who was driving, that person named, or purportedly named, Stephanie Roth. Officers indicated they confirmed, or she confirmed, the alleged suspect's identification using the law enforcement information network. He was identified in the court today as that individual that she pulled up on the law enforcement information network. So this is a preliminary examination. And so it's the burden of the prosecutor to provide sufficient evidence that there's probable cause. And that's probable cause that a crime was committed and probable cause sufficient to charge you with those crimes. This is not a trial date. This is not a hearing on your bond violation. And so the burden here, probable cause, is simply more than mere suspicion that the crimes alleged were committed. It's a relatively low burden. The statute provides that this hearsay evidence can be admitted if certain standards were met, that being that the statement purports to narrate, describe, or explain infliction of a threat or physical injury upon the declarant. The actions in which the evidence is offered under this section is an offensive involving domestic violence, and that the statements were made at or near the time of the infliction or threat of physical injury. Evidence of the statement made more than 5 years before the filing of the current action or proceeding would be inadmissible. And then the circumstances, the statements are made under circumstances that would indicate the statement's trustworthiness, and the statement was made to a law enforcement officer. So here we have a statement made to a law enforcement officer. We have testimony through the law enforcement officer that the victim stated that there was a domestic relationship or a previous relationship between Ms. Solis and the defendant as to circumstances that would indicate trustworthiness. Officers arrive and they find a victim whose demeanor is upset, who's crying and who's afraid, or seeming afraid, and who narrates an incident. And it would have been nice to have the police verify or investigate whether or not this defendant was in fact in that zone for the purposes of confirming he was there, since he's on GPS tether, but it's not necessary for probable cause. Maybe for beyond a reasonable doubt. So that's an issue for trial. With that being stated, there's a count 1 here of a felonious assault. The assault allegedly having occurred being using a knife to assault Miss Maria Solis. We have testimony that supports that. Count 1 will be bound over to the circuit court. Domestic violence is habitual offender 4th offense notice, which enhances the penalty. That's going to be bound over to the circuit court because I find that there's sufficient probable cause as to the count 2 and habitual offense notice. Let's see, your bind over date's going to be.
No. This is, it's.
Do you have something you want to say,
No,
sir?
he doesn't. No, he don't. No, you don't, because this is perfect. This is the probable cause standard. This is just the way it's gonna work right now, okay? You're not, but we're not gonna do anything on the record that you can hold against you, okay?
I don't think.
You're not gonna, no.
I think this evidence, this is not.
No, we're not gonna talk about this, okay?
It's not being shown.
Okay, yeah, but it's only a preliminary
If that
exam. She
evidence was
explained to you
shown,
what the preliminary exam is, and she told me,
If that
explained to you the
evidence was shown
standard
was
here.
there, I would be set
We will
free.
have our date.
I know.
We'll have our date.
Okay, that's what a trial's for.
But I'm
Exactly,
saying,
we'll have it.
today would be a good day to show that.
Today is not the day for you. Today is probable cause.
That probable cause would have showed me.
What probable cause?
Of the video.
What is probable cause?
Probable cause is to bond over circuit court.
No, what is probable cause? I didn't say what does it do. What is it?
Enough evidence.
Probable cause is what?
No, it was to bond over circuit court.
Exactly. So I found that there's enough evidence to bind over to circuit court. You have an attorney, correct?
Yes, I do.
Okay, and so she's here to help formulate your defense?
I've been telling her about the video,
Yeah.
and like, it doesn't come up here.
Well, because this may not be the appropriate venue then, correct?
Right.
Okay,
I apologize.
thank you. Your bind over date is going to be October 25th. That's the date that the circuit court gets the file from the district court. That's not the date that you need to appear in court. Your next court date will be a pretrial. Ms. Donnelly will be made aware of that court date. Do you have any questions?
Yes, can I retain a new lawyer?
You can always hire a lawyer at your expense. You can always do that.
I got one, like, you know what I'm saying?
Yeah, you just gotta hire them.
Because I already hired them.
Yes.
I got hired them, so I know what.
Not on this file though.
No, he has one on his other files up at the circuit court.
Yeah, you just gotta hire them on this one and they file an appearance.
Okay.
Okay. Any additional matters for the record?
Not from the people, Your Honor.
Not for defense, thank you.
Bond continues. You're all set.
Thank you, Your Honor.
You're welcome.
Well, I mean, and, well, I don't have my own camera. You don't have any here? Okay. You know, we can do JSG and just-
Oh, yeah.
There's cameras. There are LCD cameras,
Oh, no,
right?
I mean, he's in the area. It's not gonna be there. They should pick them up in there.
Yeah, but it is, there, you know, she says things like chasing her around, I mean, obviously,
Agreed.
you might have to either assess it or.
I'd love if it was this. There's nothing to set up.
On the record, the matter of the people of the state of Michigan versus Jessica Marie Gonzalez, file number 23-02478. Council appearance.
Jeff Brodovich on behalf of the people, Your Honor.
Jeffrey Roth, on behalf of Sarah Marie Gonzalez, who is standing to my right.
Okay, so today, this matter was scheduled at 8:30 for an examination. Mr. Brodowitz, you said you had voicemails from the victim?
Yes, Your Honor. I did get in touch with the victim. He is unable to appear here today in court, so the people are unable to proceed at this time.
You've already provided the court with the knowledge that the people are requesting to dismiss this matter without prejudice. That means they can reissue the charge against you. Do you understand that? Okay, do you have any questions? Okay, any additional matters for the record?
No, Your Honor, thank you.
You're all set. Mr. Abbott. Are we running an exam today?
Yes, Your Honor. I understand he has one witness.
My other officer did show up, Mr. Abbott, so I
So he's got two.
Okay, Mr. Milks,
Yes, Your Honor.
what are we doing with your case?
I think we're just continuing the PE. What's that?
All right, we're finishing the PE, you mean?
Yes, I'm sorry. That's what I was.
Okay. Okay, sounds good. And then. Those are all PCCs. Okay, sounds good. You ready?
Yes.
Are we ready? Should I bring the witness in? Yes, please. Okay, on the record in the matter of the people of the state of Michigan versus Daniel Javier Martinez, at file number 23-01304, council appearance.
Each councilman on behalf of the people.
Good morning, Your Honor. Steve Mills on behalf of my client, who is present and staying to my right at this time.
Okay, so today was the date reset to continue an examination that we began back on August 11th. I think at the time that we adjourned, Mr. Milks was going to begin his cross-examination or continue his cross-examination.
That's correct.
Okay, any preliminary matters before we continue?
No, Your Honor.
Okay, now you can recall the witness. Yeah. Right here. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay. And again, I'm gonna have you state your first and last name.
Gabrielle Palmer.
Ms. Palmer, you remember the rules from last time? We need verbal responses, no head nods or head shakes, correct?
Yes.
And then also, if there's an objection to a question that's asked to you, you would stop responding. I'll make a ruling on the objection and then I'll tell you if you can give that answer or not, okay?
Okay.
Okay, you can proceed, Mr. Mills.
Thank you, Your Honor. Morning, how are you? And ma'am, just because we're kind of picking up where we left off last time, just want to go over a few things just real quick. Since we were here last, have you spoken to anyone just regarding your testimony up here?
No.
Regarding like what you said last time, regarding what's going to be happening today? Have they spoken to you about that? Has anyone spoken to you regarding the preliminary examination here today?
No.
Not from the prosecutor's office?
I don't understand the question. I'm sorry.
Since the last time we were here, I think it was August 11th.
Yes,
Have you spoken to anyone from the prosecutor's office?
no, I haven't. I've spoken to my lawyer, but
I think she's referring to myself, Your Honor.
I'm sorry. So have you spoken to Ms. Castleman?
yes,
Okay, all right. And did you talk about your testimony here today? Did you talk about what you're
No.
going to say here today?
no,
Okay. Did you just go over kind of what to expect?
no, I didn't,
So what did you two talk about?
we didn't talk about anything. We just,
Then last time we were here, you indicated that you were on certain medications, including lithium, desperate, some anxiety medications. Is that correct?
yes,
And have you taken those medications here today?
yes, but I've been weaned off medication.
You've been weaned off, but you are still on some of those psychotropic medications. Is that right?
Yes, I'm on lithium. And Abilify.
So I understand we're going to be getting into, I know, some uncomfortable discussions here. Okay.
Yeah.
If at any time you need a minute, you need me to stop, or you just need a moment, just let me know, and I'll hold off on everything. Okay. My goal here is not to embarrass you or do anything along those lines. So make sure you just let me know. Okay.
Okay.
So going back to April, on that evening, when you indicated that you woke up and you indicated Mr. Martinez was, I think, spooning from behind you. Is that right? I'm sorry, I'm talking about the time when you were indicating that the two of you had intercourse. I think the two of you woke up. Do you recall that?
I recall him. I was woken up with him in between my legs. And I was really tired and sick, so I asked him to get off of me. And he got mad at me and ripped me from side to side in my hair.
Okay. You indicated that his penis was in between your legs. Is that right?
He was inside.
He was inside. And do you recall making that same statement to police?
Yes.
And do you recall saying that, or telling police that, and I'm quoting here, that his dick was between my legs? Do you recall saying that?
Yes, I was very
And do
upset.
you recall telling officers that after that, you asked Mr. Martinez what he was doing? Do you recall saying that?
Yes.
And after asking what Mr. Martinez was doing, he asked you to have sex. Do you recall that?
What?
Do you recall that you told officers that after he said he wanted to have sex again? Do you recall saying that?
No, I'm sorry, no, I don't.
And do you recall then telling officers that then Mr. Martinez placed his penis in your vagina and then the two of you had sexual intercourse? Do you recall saying that?
Yes,
You do recall saying that?
it's very vague, but I was very exhausted and
So it's kind of coming back to that he asked to have sex with you then?
no, he wasn't.
You said you remember making that statement to police officers, is that right?
No, I don't remember.
Is there a reason that you would lie to police officers?
No,
I would have just object as argumentative. I don't think there was any, she's stating that she didn't remember, not that she lied to the police.
Accurate. Objection sustained.
All right. You agree that your statement to police that day is different than your statement here. Is that fair to say?
Yeah.
Okay. Um, Do you recall telling police officers that you did not say no to Mr. Martinez, but that you just let him do it? Do you recall that?
Yes.
Okay. So then you would say that you did consent to him having sex then?
I just let him do it, yes.
Okay. All right. So after you gave consent, then the two of you had sex, and then I think went back to sleep that evening. Is that right?
I don't remember.
Okay. Do you remember falling asleep after that?
I was exhausted.
Okay. Well, Mr. Martinez, he was on probation, I think, at that time, or on parole. Is that right?
Yeah.
And you've spoken to his parole agent, Mr. Gleason. Is that correct?
Yes, I did.
And Mr. Gleason called you up, in fact, to ask whether or not Mr. Martinez lived with you. Do you recall having that conversation?
No.
You do recall Mr. Gleason calling you, is that right?
Yeah, but I don't remember him saying that he lived with me.
Did he ask to confirm whether or not the two of you lived together, or whether he was residing with you?
He asked if he could stay there, but I didn't want him to stay there.
But did you tell Mr. Gleason that you could?
Yeah, but I didn't want him to.
I understand. Do you need a minute? So I do understand you said that you did not want him to live there, but you told Mr. Gleason that was okay. Is that right?
Yeah, I was scared. I didn't want.
You were scared of Mr. Gleason?
No, Daniel.
I just asked that Mr. Mills let her finish her answers. I feel like she's being cut off multiple times. Thank you.
You've indicated you've had a little trouble with some memory. Is that correct?
Since April, beginning of April, yes, it's hard to remember everything, but I was exhausted. I had COVID from him. He gave me COVID and
So at that
I would
time,
just ask that he let her finish her answer before asking his next question.
she did finish her
I
question.
don't believe so.
Was there more that you wanted to say to that? I thought she was finished.
sorry.
Yeah, thank you. At that time, were you also on higher doses of lithium than you are right now?
No, I was not on any medication at all.
So you were unmedicated at that time, is that right?
Yeah.
Okay. Is it fair to say that being unmedicated at the time, your thoughts may have been a little scattered?
I don't believe so, no.
And when you spoke to Mr. Palmer, that was on or around April, I'm sorry. When you spoke to Mr. Gleason, that was on or around April 4th. Is that about right?
April 4th. I don't know the exact date, but I spoke to him.
It was around the time of this incident though, is that correct?
Yes, it
Okay.
was.
You indicated at one point that there was a screwdriver, is that right?
Yeah.
Did you point out the screwdriver to police?
No, because I couldn't find the screwdriver. He had thrown it at some point. Tried to assault me with it.
So to your knowledge, did police collect the screwdriver?
At some point, yes. It was later on. I don't know when. Yes, at some point that I told him about it.
Did you actually observe them with the screwdriver?
No,
Oh.
it was at a different time. It was a few months later.
So police returned a few months later to your house?
Yes.
Okay. Do you remember which officer you spoke with?
No, I don't. Not sure. She had red hair. Her name.
And at that time, you're saying several months later is when they collected the screwdriver?
Yes, during a different time. It wasn't. I don't. That's why I had. Breakdown, like,
What do you mean you had a breakdown?
I was angry with my neighbors for not hearing me. Screaming for help. I found the screwdriver finally in my house and I threw it on the ground.
You found the screwdriver several months later?
Yeah, it was a couple months later. I found it in my house somewhere and I threw it on the ground and the police, I told them that's the screwdriver that Daniel Martinez threatened me with.
Police
They
came by.
they must have collected it. I don't know when. I don't know. I didn't see them grab it, but I know that they took it.
I just need some clarification on that. You found it a few months later, and did you call the police again?
I had neighbors call on me.
The neighbors called the police?
Yes.
And then when they arrived, they collected the screwdriver?
Yes, I told them that the screwdriver was the screwdriver that he used to try to hurt me with.
Did you ask your neighbors to call police or did they call police on their own?
They called on their own
Were they calling for a different matter?
because of how I was acting, because I was upset.
So you were upset, were you
was
yelling and screaming or something?
Yes,
Okay, and that's why they called police?
yes.
Okay. police take you away that evening?
Yes, they took me to the hospital.
They took you to the mental hospital, is that right? Were you in there for a few weeks?
I was there for a week and then up to a month in St. Lawrence.
And thank you very much, I appreciate it. Thank you.
Okay, redirect.
Ms. Palmer, can you tell me, when you woke up and Mr. Martinez was between your legs, can you tell me about your feelings at that time?
I was frustrated.
No, I'm sorry, objection. This has already been asked and answered at the last hearing at this point. She's bolstering, she's not asking anything new at this point.
Mr. Milks directly asked about consent, about whether she was consenting when they were quote unquote having intercourse, when she was sleeping and woke up inside of her. I think it's.
He did ask whether or not she gave consent. Your question though is about her feelings at the time.
Yes, I'm trying to extrapolate on what that means.
Your objection was that she was bolstering.
Yeah, bolstering, this has been asked and answered, it's cumulative at this point.
Well, it's redirect, so I think she's allowed to redirect since you brought it up as to whether or not she gave consent. So objections overruled.
So I can ask some more. So can you tell me that the answer to that question? I'll ask another question. What were your feelings at that time?
I was surprised that he was on top of me, and I was tired, frustrated. I didn't want him touching me.
Did you feel that you could say no to Mr. Martinez?
I asked him to get off of me, but he was angry and mad. And I just remember him grabbing my hair, and that's all I remember is him grabbing my hair and pulling me side to side, and then getting off of me at that point.
Right, when we talked about, when Mr. Mills asked you about the question about stating that you let him do this, can you tell me more about this, I guess, how you were feeling around that, whether you had any choice in the matter at that time?
I just kind of gave in. I always gave in.
Why did you feel like you gave in?
Like you said, I feel like I don't have any choice in it, in the matter.
And why did you feel like you didn't have a choice?
Because he's, I don't know, I don't know.
Can you tell me more about the fear of what would happen if you didn't let him?
Objection, Your Honor, leading question, just assuming that there was fear.
Objection sustained.
Well, she said he's scared, but
She didn't complete that statement.
okay.
Since she didn't know.
Did you have any fear at that time?
Renewed the same objection, Your Honor, again, it's assuming that there was fear.
I'm
Leading
asking,
She's
question.
asking
I'm
now.
asking, did you have any fear? Did you have any fear at that time of Mr. Martinez?
The screwdriver thing scared the crap out of me. Having somebody come into your house in the middle of the night is scary. I don't know how to explain it. Like, it's hard to explain something like that.
And you have fear at the time when you woke up and he was on top of you.
Yeah, I didn't like. I was tired. I was more frustrated with him. I've known him since I was 18 years old. I don't know.
Were you fearful or not?
No, I was more angry at him.
Can you tell me about that anger in terms of whether you wanted to have sex with him at that time? Or not?
No, I did not want to have sex with him. I
Okay.
was tired. I didn't want anything to do with him in that sense.
And after you had tried to push him off and then he grabbed your head, did he continue to have his penis inside of you?
He was still inside of me at that point, but then he got off of me. Like he did get off of me.
And when there was that call with Mr. Gleason, can you tell me more about what you said to Mr. Milks about being scared of Mr. Martinez in terms of what you said to Mr. Gleason?
What?
When you talked to Mr. Gleason, when Mr. Milks asked you that question, and you said that you were not scared of Mr. Gleason, you were scared of Mr. Martinez. Can you tell me more about what you mean by that?
No, I can't.
When you found the screwdriver, how did that affect you mentally?
It screwed. It messed me up. I lost it.
And when you went to the hospital, did you receive any treatment based on what had happened with Mr. Martinez from April 4th to April 7th?
I got treatment for myself.
Okay. Did you get
I
him?
was depression and stuff like that.
Did you get any treatment related to what had happened to you in April?
I was seeing a therapist.
Did you talk to the therapist about Mr. Martinez?
A little bit, not recently.
But when you found the screwdriver at that time, did you talk to the therapist about?
No, I'm sorry, this is outside the scope of our cross. So we did bring up, obviously, St. Lawrence Mental Health Hospital and do anything regarding a current or ongoing therapist.
I'm talking about at that time, once she found the screwdriver, because that was brought up during the cross, that she went to the hospital after having a breakdown. It is an element of CFC first, whether there was mental anguish or not.
I get that, but he's saying it's beyond the scope of his cross.
I'm talking about the specific time when she went to the hospital that Mr. Milks asked about. I'm asking whether she talked about or received treatment or what had happened with Mr. Martinez at that time.
While she was hospitalized after
Yeah.
junction overruled.
Thank you.
So did you receive any treatment about what had happened with Mr. Martinez?
No.
And so you didn't talk to a therapist about what had happened with him during that
Objection.
time?
This is cumulative, once again, asked and answered.
He just answered no. Objection sustained.
All right, I don't have any further questions at this time.
You just indicated, Ms. Palmer, in your redirect with Ms. Councilman, that during that interaction when you woke up and he was inside of you, that you were angry and that you said you didn't tell him no, though, but that you told him to get off of you. Is that what you told?
Yeah.
Okay. So you told him to get off of you? Did he get off of you?
He was mad, assaulted me by my hair, but he did get off of me at one point. Yeah.
Okay, so when you say at one point, did he
After
complete
he
the act or he assaulted you and then he got off?
He was, yes,
This is when he pulled your hair?
He pulled my hair and then he got off of me.
Okay, thank you. Any cross or redirect based on that?
No,
Anything for you, sir?
Sorry, Your Honor.
Your turn.
While he was pulling your hair, is that when he also, when he stopped as well? Is that what you're saying?
No, he was still inside of me, but he went like this and then he got off of me. He was upset that
He was upset that what?
that he couldn't have sex, I guess.
And is that the same statement that you made to police officers?
I'm not sure what I told the officers. I was exhausted.
Do you recall? Do you recall telling police that Mr. You recall telling police that you just let him do it? Is that correct?
Yes.
Your Honor, thank you, Your Honor. That's what she's thinking.
Thank you. May this witness be excused or any questions?
Yes, I don't have any other questions.
Okay, thank you, Ms. Palmer. You may be excused. You can call your next witness.
I don't have any further witnesses, Your Honor.
You calling any witnesses today?
No, Your Honor.
You can proceed to argument.
Mr. Honor, at this time, I'm going to be asking for bind over on count 1. Of unlawful imprisonment. The victim did testify that the defendant, Mr. Martinez, would not let her leave. He at first broke into her house. I know that it's been over 60 days since our last preliminary examination, but the victim did testify that Daniel Martinez restrained her by means of that screwdriver and did not let her leave. And also, I believe there's testimony about secretly confining and knowingly restraining Ms. Palmer so she could not leave during these days, and knowingly restraining her to facilitate the commission of criminal sexual conduct or felonious assault, namely the assault with the screwdriver that he was using to commit the unlawful imprisonment. This incident started back on or about April 4th to April 7th of 2023, that the defendant originally broke into the house after being told that he could not stay there any longer. Broke in, did damage to the front door. There were divots in the door. She tried to push him out of the house. He then waved the screwdriver around. It was on his side. Said that if I cannot have you, no one else can. He basically terrorized her with the screwdriver, committing felonious assault, namely count 3, in which I'm asking for bind over on. We have testimony as well that Mr. Martinez strangled Miss Palmer, that he restricted her breathing, that she could not leave. She was strangled, I believe, multiple times. She was trying to claw his hands off of her. Namely, the unlawful imprisonment occurred over these 3 days, but specifically occurred in the bathroom as well, where he would not let her leave. She was trying to leave the bedroom at one point as well. and he wouldn't let her go anywhere. He kept holding the screwdriver for hours and hours. And then at that point, the strangulation occurred. There was one point as well during these days that Miss Palmer woke up. She was sleeping. She was not conscious. She woke up to his penis inside of her vagina, regardless of whether we're arguing consent afterwards, which I don't believe there was evidence of consent in this case. There's evidence of force and coercion. She was physically unable to consent at the time. She was unconscious, asleep. She woke up and his penis was inside of her. That is criminal sexual conduct. Further, he used force and coercion to accomplish criminal sexual conduct with Miss Palmer, that she woke up with his penis inside of her vagina. He grabbed her by her hair. She tried to get him off of her. He didn't get off of her. He kept his penis inside of her vagina, yanked her around by her hair, and then finally got off of her. It doesn't matter whether the act was completed or not. Under the actual law in this matter, I think that there's also a testimony presented to enhance this matter to include personal injury. So I would be asking for criminal sexual conduct in the first degree instead of criminal sexual conduct in the third degree. I would ask for that as an alternative bind over if the court does not find probable cause for personal injury. But I believe there's been testimony presented by Miss Palmer in direct questioning that she is mentally anguished by this incident. We saw her cry in court. During the testimony, she has been scared. Finding the screwdriver months later, she was so angry and upset about what had happened that she had to get mental health treatment. And I understand that she has pre-existing mental health issues, but that does not diminish the fact that she suffered mental anguish from this incident. I believe that there is evidence of personal injury. So I'm asking for a bind over on MCL 750.520B, multiple variables, both force and coercion, personal injury, and force and coercion, physically helpless and personal injury, as Miss Palmer was sleeping at the time of the sexual penetration. I would also ask for that count of strangulation to be added, MCL 750.84, to Gabrielle Palmer, because he did intentionally obstruct her breathing. I could ask for more than just one count of strangulation, but I'm only asking for one. I'm also asking for a count of home invasion first degree to be added, as Mr. Martinez did break into her residence. He had no permission to enter the residence. She just saw him. She saw a shadow in the kitchen. He told her that he broke in. He damaged the front door. There were divots in the door. She doesn't know exactly how he got in, but I don't need to, even when it comes to home invasion first degree, when someone has the intent to commit an assault or did commit an assault and or armed with a weapon, as Mr. Martinez was armed with a screwdriver, and Gabrielle Palmer was legally present in the residence, I don't have to necessarily prove breaking even by a probable cause standard, but I do believe that he broke in. From the evidence, he broke into the home at that point. So I would be asking for the count 1 to be bound over, count 2 to be bound over as criminal sexual conduct in the first degree under multiple variables, count 3 to be bound over in terms of felonious assault with a screwdriver, count 4 to be bound over in terms of the domestic violence that occurred during this time. That is a misdemeanor that follows this case, so the court does not need to make a probable cause ruling on that. And then I would be asking for the added count of strangulation and the added count of home invasion in the first degree. I'm also going to be binding over this when this matter is, or if this matter is bound over, I would be adding a habitual fourth offender notice due to the defendant's criminal history. And I would be asking for the bind over as stated at this time. Thank you.
Mr. Milks.
Thank you very much, Ron. Your Honor, understanding that this is a preliminary examination with the lower burden at this point, the court is to make or can make some determinations regarding credibility. First and foremost, we do have some significant issues regarding this young woman's credibility. The fact that she's admitted that she's on some pretty powerful medications at this point, that she has been to St. Lawrence, the fact that she's had police called on her by her neighbors due to some of her outbursts this time, I think is going to bring into question some of her testimony. Furthermore, Your Honor, regarding, and I just want to start with this request for a home invasion first, she admitted that she allowed him to stay there. She told his parole officer that he could stay there. while we have this conflicting testimony, that has been a lot of what's been going on here, where she has been significantly has had significant confliction with her testimony, where she's saying to one, yes, he can stay there, you can't break into your own home. There was no indication that he was evicted. The prosecutor doesn't put forth any evidence of that. The prosecutor doesn't put forth any evidence that he was not allowed to stay there. There was a lot of testimony regarding Ms. Palmer being mad, being upset, being frustrated with him. On top of the fact that she has some mental health challenges, which could rile her up or get her excited or get her upset. Just because she says at one time or later on that, no, I didn't want him there, it's whether or not that's conveyed. And that was not conveyed. In fact, the very opposite of that was conveyed here today in court, that yes, I did give consent for him to live there. It cannot be home invasion. Regarding count 1 as to the unlawful imprisonment, the prosecutor puts forth the theory regarding this being a secretly swirling her away, essentially hiding her, preventing her, preventing other people from coming in to see her. There was no indication of that. There was no indication that she couldn't leave the house. There was no indication that at certain points she wasn't able or free to go, is my understanding, Your Honor. The no indication that she had reached out to other people, that other people were not able to find her or anything along those lines, is my understanding. There's no indication that there was some sort of secret swirling away, secretly hiding her or confining her. And the purpose of that is so that other people couldn't find her. There's been no evidence of that, Your Honor. This court cannot find over because the prosecutors failed to support even a minimal showing that the elements have been met here. Regarding the CSC count, I know the prosecutor is asking for a first. In this circumstance, she admitted to telling police officers that his penis was between my legs. Upon further clarification, it was not in her vagina when she woke up. She said that after she said, okay, fine, or gave consent, that the two of them did have intercourse at that point.
At the time that she woke up, that's not my recollection of her testimony.
When she was here, Your Honor, I asked her regarding her statements that she made to police.
I recall that.
And at that point, she did say that she consented to having sex.
She was very clear more than one time today, I think at least 2 times, that when she woke up, he was inside of her.
And Your Honor, there was also when I said, asking her regarding whether or not the sex was even consensual, she did admit that it was consensual. There's been no indication that this hasn't been a pattern of something that they've done before or in the past. There's no indication that it wasn't consensual. Here, the very opposite. It was said this was consensual. This cannot be a CSC if she's going to get up there and say this is consent. And I think that it is irresponsible for a prosecutor to ask for a higher charge when we have a situation where she said, I consented. Otherwise, Your Honor, I would ask that the court otherwise not bind over on the remaining counts that I'm not just going to specifically address at this point. Finding that the people have not met their burden at this time, and I would ask this court to dismiss the proceedings. Thank you very much, Your Honor.
Yes, Your Honor. So in terms of a credibility determination or preliminary examination, the People versus Anderson case requires, even if there's a question regarding credibility, that should be left up to the trier of fact. It needs to be a clear and unequivocal lack of credibility that results in a non-binder under that type of assessment. I don't think that the fact that she's honest and upfront about her mental health issues and her treatment that she's received, medications that she was on, there's no evidence that that medication or treatment makes her a non-credible witness. Further, he did secretly confine her in the bedroom and he would not let her leave. He threw the screwdriver at one point. She was there in the bedroom for hours. He would not let her leave. He said, I could kill you with my bare hands. I don't need this. Threw the screwdriver. He would not let her leave leave. She was trying to let him leave. She just wanted him to leave, wouldn't let her leave the bedroom, wouldn't let me go anywhere. He kept holding that screwdriver until from 5 a.m. until the afternoon. He put it right up to her neck. He strangled her in that bedroom. She had to claw his hands away when she was being strangled. There was no opportunity for her to seek help. He was secretly confining her at that point and committed another felony strangulation when he secretly confined her in that location. But I'm asking for all three alternatives under unlawful imprisonment, that he both knowingly restrained her, secretly confined her, and knowingly restrained her to facilitate his commission of criminal sexual conduct and or felonious assault and his strangulation of her. And further, she did agree initially, this was not his house. She agreed to have him stay over for one night or a couple nights. At some point, she didn't want him there anymore because of this type of behavior. She called the cops. He ran away from the home. Once the cops were called, he ran away and then fled the scene and then showed back up at 5 a.m. inside of her house without permission after she had already kicked him out. That is not his home. You can't just show up and break into someone's home. That is home invasion. She never said on this testimony that she said, okay, fine. She said, I did not want to have sex with him. You cannot consent when you are sleeping, first of all. Second of all, she pushed him off. I don't even need to prove that a victim tried to resist. She did try to resist. She woke up. She did not want
She
to.
testified, she told him to get off.
Yes, and he ended up using force, but she did not want to have sex at that point. I don't see how, and even if there is a question of consent, that is an issue for the trier of fact in this matter. That is not an issue for preliminary examination bind over. I think there's no question in terms of there is probable cause for mental anguish in this matter. And again, I'd ask for bind over as I previously stated.
Thank you. Today was the date to continue and complete the preliminary examination. The burden is on the prosecutor to establish that they have sufficient probable cause that a crime was committed and insufficient probable cause as to each charge to allege that you committed those crimes. This is not a trial. It's not beyond a reasonable doubt. It's a very low burden. It's more than mere suspicion that those crimes were committed. The court is the sole determiner of credibility today. At trial, it's trial of fact. And so I don't think Mr. Milk's argument was that there was a question about credibility. I think his argument was she lacks credibility. We heard her testimony beginning back in August 11th, I believe. Ms. Gabrielle Palmer, who identified the defendant in court, indicated that at the address of 935 Bank Street, City of Lansing, Ingham County, State of Michigan, making a venue in this court appropriate, showed up unannounced to her house about April of 2023. I believe it was the beginning of April. And that she was gaming in the back room at the time, and the dog alerted her that someone was at the door. When she went to the door, the defendant was at the door. The testimony was that she felt bad for the defendant because it was raining, that they had dated back in 2014. She's also indicated today on the record that, she's known him since she was 18 years old. She said she did not invite defendant to the home, but she did allow him to stay. She stated at that time until Monday, and that was a Friday that he arrived. She said the defendant stayed longer and that some jealousy ensued regarding her speaking to another gentleman online. She testified that she ended up getting sick. She stated the defendant wouldn't leave and started what she termed as taking advantage of her home. Didn't expound really on what that meant. She said that she did call the cops at some point, that the defendant fled, but then returned at 5 o'clock in the morning, at which time she said she saw a shadow in her kitchen. She came off the bathroom into the kitchen, and she didn't say anything, and that the defendant stated to her, "Do you know how long I've been standing here?" Allegedly hadn't been standing there for about 30 minutes. She said there was damage to the door from the defendant prying the door open. She stated at the time that he threatened her with a screwdriver. She indicated that she did try to push the defendant out. The defendant wouldn't allow her to leave when she tried to retreat, and that he ushered her back into the bedroom, which is located in the back of the house. Again, pulled out a screwdriver and started waving it around and made a statement along the lines of, "If I can't have you, nobody else can." She stated she eventually fell asleep, that she woke up, and that when she woke up, that the defendant's penis was inside of her vagina. The victim testified that she was in pain and that the defendant grabbed her by the hair and yanked her head from side to side. She testified then, back on August 11th, that she was frustrated when she woke up and he was inside of her, and that the pain was caused from him pulling her hair. She felt that she couldn't go anywhere and that the defendant wouldn't let her leave during this altercation or this time period. And eventually, she claimed she called her mother, who saved her. She says she was, at the time she testified, she was scared and frightened for her life, that she thought the defendant was going to kill her. She testified that during this time period, the defendant strangled her and he touched her face with the screwdriver. He at one point cut off her air supply, and that she had to have testing to ensure that her blood vessels were not broken in her neck when she went to the hospital. She later testified that she wasn't sure if it was that the defendant was trying to just convince her to stay with him, or if he had planned to kill her. That the victim found her phone, because she testified that she was unable to locate her phone, and that she dialed her mother. On cross-examine, primarily today, some of that testimony did change. When questioned by Mr. Milks as to whether or not she was fearful, I think she made it clear that she was not afraid of the defendant, that she was angry, and that she was frustrated. And although she did testify that she did not tell him no during when she woke up with his penis in her vagina, that she did tell him to get off of her, that he got angry because of that and assaulted her, and then he eventually got off in her terms. There was testimony today that although she did previously state that she told him that he could stay till Monday, when it was Friday, that she stated under oath that she spoke to the defendant's parole officer, and that she told the parole officer that he could stay there. She was questioned about whether or not she wanted him to stay there, what her true intentions were, but her testimony was that she did let him stay there, and that she did tell the parole officer that he could stay there. The victim testified she later located the screwdriver that was allegedly used during the commission of the assault, that she was having some kind of episode in the house where she was yelling and screaming, causing her neighbors to call the police. Officers appeared, collected the screwdriver, and she was treated for mental illness during that time. The defendant has been charged here in count 1 with unlawful imprisonment, alleging that he did restrain Ms. Palmer by means of a weapon or dangerous instrument, or secretly confine and knowingly restrain Ms. Palmer, or knowingly restrain Ms. Palmer to facilitate the commission of a criminal sexual crime. Her testimony previously was that when he appeared or reappeared after her having called the police and him fleeing, that he ushered her back into the room in the back of the house, that he would not let her leave, because she did testify that she wanted to leave and he wouldn't let her leave. He ushered her back in the back room of the house. He pulled out a screwdriver and assaulted her or threatened her with that. During that time, there is testimony that he did facilitate a criminal sexual crime during that time. The testimony about the criminal sexual crime in the third degree, there is a motion to, you're making a motion to add a count of first degree or amend this count? Is that what you're doing?
I would just ask to amend that count, to make it first degree instead, and first degree multiple variables in terms of the physically helpless and force or coercion.
Okay, as to the motion to add a count or to amend count 2 to criminal sexual conduct in the first degree, the testimony that we have regarding this incident was that she woke up and that his penis was in her vagina, and that she didn't want to have sex with him, that she was frustrated and she was angry with him. I believe her when she said she was not fearful of him. That's when she also indicated she's known him since he was 18, although she did previously on August 11th say that she felt like he was going to try to, that she was in fear for her life. So I think these issues are issues that create concerns about her credibility, that you can't go one day from saying you felt like you were fearful for your life to today saying that you, well, you weren't fearful of him. You just was frustrated. And she stated she was frustrated on the 11th. I think that's been a common theme as it relates to how she felt about that sexual act. If what she's saying is true, I would be frustrated too. If someone I didn't really want to stay in my house was there and wouldn't leave and ushered me in the back room of the house with a instrument such as a screwdriver, and I felt defenseless or that I couldn't like get out of there, and then I wake up and they think that I want to be sexual with them. I think that would make me frustrated. But she stated she was angry. She also stated that she told him to get off of her. She was very clear as far as I'm concerned that his penis was inside of her vagina at that time. Do not believe we have enough to upgrade this to a criminal sexual conduct first degree. I do think that there is probable cause sufficient as to count 2 based on her testimony as charged, which is criminal sexual conduct in the third degree by force or coercion. I don't even know that I mean, the defense can argue consent, I guess, at trial, but if you look at the elements or what needs to be argued for consent, she was sleeping and she had already been, in her terms, assaulted and threatened and put in the back room of a house. So it's criminal sexual conduct third degree by use of force or coercion will be bound over along with the count 1 of unlawful imprisonment.
Yeah.
Yes.
Can, in the alternative, are we also binding over on the physically helpless third CSC third degree since she was asleep at the time?
That we could do that. Okay, and so we will add that as well in the alternative. And then there is a count 3 assault with a dangerous weapon, a felonious assault, and that being with the screwdriver. I think we heard enough about the screwdriver today. There's sufficient probable cause as to count 3, and that will be bound over to the circuit court. Count 4 is domestic violence that will accompany. The people are requesting a count 5 of assault by strangulation. The testimony was that when the defendant returned to her home, that he assaulted her and that he strangled her, that she testified she had to, at some point when she was seen by medical professionals, have her neck evaluated to ensure that no blood vessels in her neck had broken due to the strangulation. So we will add count 5 assault by strangulation that will be bound over. People are requesting to add count 6 home invasion, home invasion first degree. And this is based on the testimony that the defendant appeared at 5 o'clock in the morning, and that he used the screwdriver to pry open the door. I'm going to deny that request because she very clearly stated here under oath that she spoke with the probation officer, parole officer, and she told the parole officer that he could stay there. Not just that she told him she can stay there, she went a step further and spoke to the parole officer. She didn't say that he threatened her to tell the parole officer that he could stay there, that she felt like she was under duress. That's not what she stated, but she allowed him to stay there. You can't invade your own home. If she changed her mind or she really didn't want him to stay there after she let him stay here, the law provides a mechanism for how you address that, and it's called a lawful eviction. And so with that being stated, I will deny home invasion or count 6 of home invasion in the first degree. The bind over date is going to be October 25th. That's the date that the circuit court gets to file from this court. You're not appearing in the circuit court on the 25th unless Mr. Milks wants you to be rearranged for some reason. Your next court date will be a pretrial in circuit court, and Mr. Milks will be made aware of that. Do you have any questions today, sir?
Your Honor, I'm sorry, just for clarification. Regarding count 2 in the alternative, it's the CSC third in alternative with the mentally incapacitated. Is that my assumption?
Yes.
Okay, thank you, Your Honor.
Okay. Do you have any questions, sir? Bond was set at 30,000 as surety. Are we addressing bond? And also with GPS tether, 2,000 feet exclusion zone.
No, Your Honor, there's no need to address bond in this matter. He's currently also in Nuevo right now serving a sentence. The only other thing we would bring up, Your Honor, is just there's been indication that people are holding out on evidence regarding the screwdriver at this point. So I'm just asking if the people would make sure that we get that screwdriver, that'd be much appreciated.
I have no information about when the screwdriver was
I'm sure you
obtained or that
don't.
I'm holding up evidence. This is the first time I'm hearing of it.
If you
And I
were
did
to
check.
discover
Yeah.
that there is a screwdriver that's been taken by law enforcement in connection with this case, Mr. Milks would like to see it.
Yes.
Perhaps
And I would
perjury
also
charges
like
if
to
they
see
don't
it.
find a screwdriver.
Perjury for lack of
For me?
bringing
Not
forth
you.
the
Oh.
the screwdriver.
Or the defendant lying about, or I'm sorry,
The
the
victim
victim
lying.
lying
I
about
don't
the
think you have
screwdriver.
I don't know that we know
I'm
this
just-
is like
I
she
can
may have
ask.
found a screwdriver. The screwdriver may have been confiscated by law enforcement. I would imagine that based on why the police were called, they may not have known what was going on with the screwdriver. And so they may have confiscated it, but not know it was in connection to a case that she was a victim on. I don't know that though, but I can assure you that Ms. Castleman is not hiding the screwdriver. And so if she has that screwdriver, she's gonna make sure you get it.
I appreciate that, Your Honor. Thank
All
you.
right, any additional matters for the record?
No, Your Honor.
Not for this, I don't,
There's a PA 53, is that what you're talking about?
that's,
So I'm trying to figure out what PA 53 was actually filed in this matter.
Do I have a PA
So-
53 in here? Let's see.
So I was just talking to the officer on this case as well, and I believe that it might need to still be formally filed. I know that he was arraigned on it, but I don't know if the paperwork was ever formally filed for the violation.
Your Honor, at this point, we have an arraignment already. This court no longer has jurisdiction of this matter, except for what he's currently been arraigned on. People are seeking new violations apparently at this point, but the court.
New
does not-
violations of what?
That's what's been indicated here, I believe, is what you're.
Well, they're the
doing
same
now.
types of violations, but so I'm not sure which PA 53 violation he was arraigned on.
Yeah, I see August 11th.
Yeah.
We set this for a PA 53 violation. It's called at 2 a.m. Let's see here. I don't have anything in my file. Typically, the PA 53 would be on this side. And there's no PA 53 on that side, so I'm a little confused as to what I arraigned him on.
And this could be a situation. We could refile the violation and deal with it in circuit court. I don't know whether it was formally filed or not.
I'm not sure either. What I do know is that the bond violations, what has been happening is that circuit court, we still have, it's our order. The bond was our order. Please send it back here. Okay. So if there was a bond violation, I don't know what this one is like. For whatever reason, there's nothing in my file that indicates a bond violation on this side of the file at least. So if it's hiding, it might be hiding wherever that screwdriver is. And so we can't find it. And so worst case, he was found guilty of a bond violation, he'd be sentenced to 93 days in jail. He's being held anyway. So we'll go ahead and dismiss whatever that bond violation is. And then if there's a new violation that needs to be addressed, we'll let the prosecutor's office move forward with that. Okay.
We will refile the violation.
Okay, sounds good.
I
Okay.
think that makes the most sense. Thank you. Anna.
No problem.
This court has signed the bind order, though, right?
I have.
Yeah. So this court no longer has jurisdiction of this case. I believe.
Well, we still are that's not what the circuit court says. It says if there's a bond violation, that it's our bond. It's our court order.
Okay.
That's what they say.
You made it through another one of my prelims. Like.
Thank you. I know. I deserve a award for that.
You do. You do. Go Patriots.
And then I have, good job.
Thank you.
Good job. Love to hear it. Too bad Big Ol didn't hear that. And then we have, I not only have to make it through yours, but now I have Mr. Abbott.
Oh, and he's insufferable.
So,
Mr. Mel, you got a little something right there.
It's a brown.
Okay, yeah.
What?
Just call me a brown.
No.
You got in trouble for insulting the Patriots one time.
contempt, I think is what we called it.
What's that?
I think we called it contempt. Yeah.
Yeah.
What? I don't
Yes,
recall that.
the contempt hearing we held for.
Mhm, Yep.
We did.
Right, I do
recall
recall that. That was not fun.
We had to call you for counsel. Okay, let's see.
My favorite was Mr. Kuntz's reaction when he drafted it as your counsel right as he walked in.
I know. He was ready to go though. Mr. Coots was ready to go.
Yeah. Yeah, but I'm not paying that bill.
Okay, let's see. How many witnesses do we have?
I believe I can do it with just one, Your Honor. Just for the courts, so the courts are where both witnesses on this are both the LPD officers, both
Okay.
night shift.
Sounds
So-
good. We're going straight through.
Okay, all right. Yes.
One. Okay, on the record in the matter of the people of the state of Michigan versus Anaya Lenise Johnson. File number is 23-02263, counsel appearance.
Jeff Rowitz on behalf of the people, Your Honor.
Good afternoon, Your Honor. John Abbott representing Ms. Johnson. She's standing to my right.
How are you, Ms. Johnson?
So how are you?
I'm doing okay, thank you. Okay. So what's going on with this file? Oh, that's what's going on. First and foremost, Ms. Johnson, in the matter of the people of the city of Lansing versus Anaya Johnson, file number 21L2618182. I received this file before me yesterday because you were supposed to appear before me for show cause on the 19th of September for a no plate because you owe $189. They brought me the file yesterday to issue a bench warrant, but Mr. Bigelow reminded me that you'll be here today. So we don't need to warrant you because you can tell me right now when you're gonna pay this.
By Monday, hopefully. I got.
In full? Or you could say, last time I heard that,
I just, rent was behind, so I needed to catch up on that before.
okay, so when are you gonna make your payment? Because you're supposed to be making payments of $50 every 2 weeks. Why don't you do $50 a month? If that's better.
By the end of next week, I have another check. I should be able to pay the whole 200. I just have to get rid of it.
Okay, when is the pay period that you get paid next week?
Thursday.
Thursday,
After
the
4, yeah.
19th?
Yes,
So
ma'am.
you're gonna pay by the 20th?
Yes, ma'am.
I know that's what you're telling me, but I'm writing that you're gonna pay $50 per month beginning the 20th. And that you'll make those payments will paid in full. And the reason why I'm doing that is so that I don't have to issue a bench warrant when you don't come next week on the 20th with all 200. If you just come with 50 after you're telling me today you're gonna pay it all and you don't pay it all, then a warrant issue. So you can pay it all. That'll be wonderful. Then we can resolve that. But know that you can pay 50 and then make $50 a month payments. Okay.
Yes, ma'am.
Okay. Now back on the matter of the state of Michigan versus Anaya Johnson. Are you ready to proceed?
Yes, sir.
Any preliminary matters?
And nothing from the people, Your Honor.
You can call your witness.
All right, thank you, Your Honor. The people would call Officer Seth Osentowski.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yeah.
Thank you. You can have a seat, officer. And can you please state your first and last name and spell both of them?
First name Seth, S-E-T-H. Last name Osentowski, O-S-E-N-T-O-S-K-I.
You can proceed, counsel.
Thank you, Your Honor. Good afternoon, Officer Osentowski. Officer, how are you employed?
As a police officer through the city of Lansing.
And how long have you been a police officer with the city of Lansing?
3 years.
All right. And were you working in that capacity on July 24th, 2023?
Yes.
All right. And how was you at that time? Were you working day shift, night shift? What shift were you?
Night shift.
Okay. So would this have been, I guess, just to clarify, you were working then the night of, it would have been July 23rd to the morning of July 24th, correct?
Yes.
Okay. And how are you dressed that night?
Basically what I'm wearing now, maybe a short sleeve t-shirt.
Full uniform?
Yeah.
Okay.
Full police.
And what were you driving that night?
Fully marked patrol vehicle.
Okay. And that night, did your duties happen to take you to 2301 South King Boulevard, apartment 1-2?
I believe it was 1/2.
Or one?
Yeah.
Okay, 1/2. I'm not sure exactly how that's read. My apologies. And is that location in the city of Lansing?
Yes.
In Ingham County?
Yeah.
All right. And why were you dispatched to that location?
It was a domestic assault that occurred there.
Okay. And when you arrived there, how did you proceed?
So initially when we arrived there, I don't know how to pronounce her first name, Anaya Johnson, I think I pronounce it, was outside. She talked to us first saying that her girlfriend called. I tried knocking on the door, she didn't answer initially. So Johnson decided to climb through a window since it was her residence at the time. And then they started, the girlfriend wasn't there. They started arguing, started bickering, both claimed assault, but didn't really want to talk to us about it. And then Johnson eventually grabbed her stuff and went outside and was supposed to leave.
Okay. And during that call, was anyone arrested at that time?
Not at that time, no.
Okay, and why not?
Just due to the fact that nobody really wanted to talk about it, they just wanted to argue back and forth, and they're just trying to keep them separated so that they can stay apart for the night.
Okay, and what'd you do after that call?
So we went down the road, me and my partner were talking, and then as we were talking, the original caller, Johnson's girlfriend, called back stating that Johnson broke out a window and that she requested an ambulance because she was cut by the glass.
Okay, so you were, I guess, redispatched to 2301 South King Boulevard?
Yes.
Okay. And when you arrived back at that address, what happened?
So when we arrived back, we seen Johnson walking eastbound. I don't exactly remember the side street off the top of my head. But she was walking eastbound. We detained her because we didn't know what we had yet. So we placed cuffs on her behind her back. And then we put her in Officer Cook's backseat of her patrol car.
Okay, and at this time, was Miss Johnson under arrest?
No, she was detained.
Okay. And do you see Miss Anaya Johnson anywhere here in the courtroom today?
Yes.
And can you indicate where she's sitting in an article of clothing she's wearing?
She's sitting to the left, black Nike sweatshirt.
Please let the record reflect the witness has identified the defendant.
Any objection to identification?
No objection, Your Honor.
Okay, ID is noted for the purposes of preliminary examination.
Did you eventually make an arrest that night?
Yes.
And who did you arrest?
Johnson.
And why did you decide to make that arrest?
There was a felonious assault that occurred that she committed against her girlfriend via strangulation.
Okay. And after you arrested Miss Johnson, how did you proceed?
I explained to her that she was under arrest. She asked if her girlfriend was going to be arrested. I explained to her no. It was like, I want to go talk to her. I told her no. When I told her no, she tried to get out of the car by standing up. I pushed her back into the seat and maneuvered her around so I was able to close the door safely.
Okay, so just to stop you for a second there. So when you informed Miss Johnson that she was under arrest, where was she at that time?
She was sitting in the back seat of the patrol car on the driver's side.
Okay. Just 1 second. Officer, that night, do you have a body cam that's issued by LPD?
Yes, I did.
And did you have your body cam on you at that time?
Yes.
And during this incident, was that body cam operational?
Yes.
Oh, okay. I am going to, permission to approach, Your Honor?
Yes.
All right. I am going to show you a brief clip of what has been marked as People's Proposed Exhibit 1. I guess, but prior to this hearing, did you review your body cam footage?
Due to the call load last night, I unfortunately was not able to review any of it.
Okay. I'm going to show you what has been marked as a brief clip of People's Proposed Exhibit 1. If you could just take a look at it for a minute. Do you recognize that footage, Officer Ossentowski?
Yes,
All right, and how do you recognize it?
that's my veiny arm.
Right, and is that appear to be your body cam footage from that night?
Yes.
And is it a fair and accurate representation of what happened that night?
Yes.
Okay. At this time, Your Honor, people would move for admission of People's Proposed Exhibit 1.
No objection, Your Honor.
People's one submitted.
Okay. Now I would like to publish for the court People's Proposed 1, play a portion of the body cam. Your Honor. Yeah, I'm trying
Click
to.
sound.
I'm trying to. Oh, wait. That should. Okay, so sorry, Your Honor. I will replay starting at 36 minutes of the body cam.
Okay, stop the share. And then exit out of the share. And when you go back into share, you need to click share sound.
Sorry. Replay starting at 36.
I'll let her know. Felony? Alright. Alright, so you are going to jail for felonious domestic, okay?
She not getting one either?
Nope.
For what?
So here's a...
How's she not getting one if she put her hands on me first?
So here's... Listen, you don't need to look back there.
How's she getting one if she
It
put her
doesn't...
hands
Listen,
on me
we
first,
already...
bro?
So it'll all go in the report and the prosecutor can decide.
No.
We can't take all your stuff, so what do you want?
Bro. So I'm going to jail. Where's she at? Let me talk to her. No, cause she put her hands on me first.
Listen,
that shit not fair.
Do you want
and
your
y'all
bag?
talking to
Do
her
you want your
mom and
bag?
stuff. Like, come
what
on
do you
now.
want?
What the fuck?
What do you want from here?
Bro.
Listen, no. Get...
Bro, I'm no!
No!
Fuck is you no? Cause that shit not fair. I do that. My knee, I just had surgery. You will go to... Bro.
Just gonna pause it right there for a second. So just for the court, Officer Ossentowski, what did we just witness right there?
So obviously I told her that she was under arrest for the domestic assault. She was not happy about the decision that was made. I tried to explain to her, like, both of their statements are gonna go into the report. I was asking about her property that she had on the sidewalk, like what she wanted to take up to the jail. And then she just was adamant about talking to the victim. So she attempted to get out. Obviously, I'm not gonna let that happen. So as she's like trying to stand up, I was able to, push her back so she's still seated, put her legs back in, and then close the door.
And then how did you proceed after that?
So after that, I obviously wasn't going to leave the back driver's door open to talk with her, to communicate with her. So I opened the driver's door and I talked to her through like the plexiglass partition of the patrol car.
Okay, at this time, Your Honor, I will be continuing. That was, sorry for the record, that was paused at 37 minutes, 1 second. I will be continuing from that point with People's Exhibit 1.
She got all these people to take her with her. But I gotta go to jail again for her putting her hands on me, bro. That shit not fair, bro. On my mom, bro. That shit is not fair. She got all these people here.
Well,
She
maybe
hit me
listen.
first. She hit me all day.
Maybe if you weren't
But I'm
acting
going to
like
jail,
this.
bro.
Stop acting like
No,
this.
but I'm going to jail. Can I call my mom?
Once you get to jail.
Alright.
What do you want out of your bag?
Yeah, alright, my phones.
Just your phones?
Both of them.
Okay.
And my money. Y'all really got me messed up, bro. Cause I'm going to jail for her hitting me. And her sister watched her hit me, bro. But I gotta go to jail cause is she going to jail? Why not? Why? Cause she called, right? Cause she was the one who called, right? Alright. 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 Alright.
Hey, Cook. She got the handcuffs off.
I'm going to pause it right there for the record. That's 38 minutes and 11 seconds. So, officer, after you were talking, we saw you shine your flashlight in there. Why did you shine your flashlight in the back of the vehicle?
So obviously, she was starting to bang on the partition, and I noticed that her hands were in front of her, which is not how we handcuff at all. It's behind the back. So that obviously raised my suspicion. And then when I shined my flashlight in the back, I noticed she was able to slip one of the handcuffs off her wrist. And I believe it was the right wrist that she was able to slip out of the handcuff.
Okay, and when you looked in the back, what was Miss Johnson attempting to do at that point?
She was just kind of kicking around, and that's kind of about it at that point in time. Obviously, I notified my partner because that's a safety hazard, and that's where we left off.
And so we heard you call. Who was your partner that night?
Officer Cook.
What's Officer Cook's first name?
McKell.
Okay. At this time, Your Honor, I'm going to proceed to play People's Exhibit 1 from 38 minutes and 11 seconds.
She got him in front of her. She tried getting out when I told her she was under arrest as well. I think she put him in front. She's working on getting him off now. So. She got one of them off. She's about to catch another charge. Yeah. $39. We have one under, but she was able to slip the cuffs during transport. Starting the transport. No, we're trying to get our cuffs on right
Every
now.
time. Alright,
Let me get an R&O charge.
Give me my phone so I can call my mom and my lawyer. Alright, we already got a police. We already got.
If you want to slide one this way. Yep.
Keep doing it. Yep. Keep doing it. Keep doing it.
For the record, I'm pausing it at 40 minutes and 30 seconds. So if you could, Officer Ostentowski, could you just describe to the court what we just viewed there?
So obviously, me and my partner, you know, she has the handcuff off. It's obviously a safety hazard. Now she technically could use it as a weapon, and we're not going to transport her like that down to jail. So we knew we had to get him the handcuffs back on. Officer Cook, started on the passenger, but moved to the driver. I did go over, I put gloves on for, safety reasons. I went over to the driver's side, but obviously there's a lot going on there, so couldn't really get involved there. So I went over to the passenger side because Officer Cook told me to. So when I did, Officer Cook started grabbing her left hand. Johnson started grabbing the patrol car's door to like pull herself out. And then that's when I grabbed onto her right wrist and I started doing like an iron wrist lock to get her hand behind her back and to use it as like a distractionary technique to hopefully be able to place her back into handcuffs. And that's kind of where we're at right now.
Okay,
So
and where are you physically in this right now?
I'm completely in the backseat of the patrol car,
Okay.
which there's not really a lot of room to move, which is later on is why I suggest taking her to the ground outside of the patrol car to gain, ability to move a little bit more.
All right, and I will begin replaying Exhibit 1 from 40 minutes and 30 seconds.
Keep doing it. Keep doing it too. Keep doing it. Keep doing it. Lawsuit. Lawsuit. Fuck is you talking about? Move, nigga. Fuck is you talking about? Move.
The ground.
I don't give a fuck. I don't give a fuck. Nigga, break my arm if you want to. Let Lawsuit. Just ask. Lawsuit. Fuck is you talking about? Move. 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 You just got another charge. Yup. Get off me. Get off me. Get off me.
Right? Yeah. Just slam my finger in the pavement.
Stupid bitches.
All right, let's get them.
Both y'all stupid bitches. Yep. Yeah. I hope y'all know. Y'all get a lawsuit. And I just had surgery. Yeah.
Remember?
Yeah. I need medical attention. Now. I need medical attention. Okay, wait till I get up. Shit. Yeah, shit. It's a two of y'all.
Let my cup go.
You shut up. The fuck?
$38. You need to slow it down. You gotta control. Just keep it coming.
Yeah, the units continue, but slow it down.
So as you stated previously, you advised that you took Miss Johnson to the ground. After you took Miss Johnson to the ground, what did we see there?
So I maintained that wrist lock, but as we were going to the pavement, my hand did hit the pavement, so my one of my fingers started bleeding. I believe it was my pinky. I don't exactly remember which hand it was. I maintained it. Me and Officer Cook were able to get both hands behind her back. You see me reposition my hands just due to the fact that she kept digging her nails into my hand. You don't really see it clearly, but while we're on the ground, she's using her leg and kicking it back up, hitting my leg. And then, yeah, we eventually get the handcuffs on and we hold her down onto the ground until more officers get there.
Okay. And just for the record, I apologize, I forgot this. I stopped People's Exhibit 1 at 42 minutes. So after you were able to get Miss Johnson back into handcuffs, how did you proceed?
So once we got her back into handcuffs, we kept her onto the ground. I don't exactly remember who the next officer was to show up. I think it was Officer Hutchins. I asked her to go into my duty bag to get ankle cuffs. That way it constricts her movement, and we put those on her. She is complaining of her knee pain. I believe she tore her ACL and had surgery on it. So we put them in there. She said she did not want to get into Officer Cook's vehicle. So I was like, all right, well, we'll put you in mine. However, she didn't want to walk at all. So there was about 4 of us. We lifted her up and we placed her in the back seat of my patrol car. And I believe an officer rode it in the back seat of my patrol car, and we took her down to Sparrow Hospital for treatment.
And was there any issues with Ms. Johnson after that?
I do not. I think she attempted to like mess with the handcuffs, but I stopped her once we were in the hospital.
All right. No further questions, Your Honor.
Thank you. Afternoon, officer.
Yeah.
Thank you for being here. You worked all night? So taking you back to the beginning of this interaction with the 2 young ladies, Ms. Lopez was in the house at first? Yes?
Yes,
Say
sorry,
it out
sorry,
loud so
yes,
we can
sorry,
record
yes,
Okay, and you first arrived at the house, Ms. Johnson was outdoors and Ms.
Yes.
Lopez was indoors?
Yeah.
And somebody had phoned the police?
yes, it was Lopez that was inside.
Okay, but even though she had phoned the police, she didn't answer the door for quite a while.
That's correct.
And finally, she did come to the door. She was just wearing a blue towel.
I think that was when Johnson was getting through the window that she did eventually answer the door.
Okay, that's what you recall of?
I believe so, yeah.
Okay, and do you recall Johnson then going in the house through the front door past the 2 officers?
Yes,
So she came back around and walked in the front door
yes,
and she collected her belongings
yes,
and took them out
yeah.
and left.
She did not exactly leave. She sat in the driveway. We even offered her a ride to go to her mom's house, but she did not want to leave.
Okay, I couldn't tell from the video. what
Right.
happened there. So, but then the 2 of you left.
Yes,
And then just minutes later, you were back.
yeah,
And at that time, you met Miss Johnson walking down the sidewalk,
yes.
and you spoke with her there.
We detained her at that point in time.
Okay, and according to your notes here in your report, Miss Johnson told you that she had been assaulted.
Yes, that's once I believe I read her Miranda, right?
Okay. And she said that Miss Lopez punched her multiple times in the face.
Yes,
And she reported that Lopez strangled her.
yes,
And she reported that Lopez thought that she actually bit Lopez's hand to get away.
yes,
And she explained that, anyway, at this point, you made contact with her as she's leaving the house? Or she's walking away from the house?
who?
You made contact with Miss Johnson?
We detained her, we put her in the back seat, and yeah, I eventually read her Miranda rights before interviewing her.
Right, okay. And your notes indicate that Miss Johnson had multiple lacerations to her face and neck and ear.
Yes, and I took photos of those.
Right, and she did not have those injuries when you guys had first arrived.
I did not observe any, no.
So in the few minutes between the time you left and the time you got back, she sustained multiple lacerations to her face and her neck and her ear.
I'm gonna be honest, I did not take a good look at her once we were first there.
Okay. Okay, so you didn't notice any injuries?
No,
And she didn't tell you about any injuries?
no.
And she didn't describe how she had been attacked by Miss Lopez until after you came back?
They both were claiming assault initially, but nobody, they just were gathering their stuff and bickering at that point. Yes.
All right. So you placed her under arrest?
After we did our investigation, we determined that she was the accused, and I advised her that she was under arrest, yes.
Okay. Did you notice? All right, so you arrested her for the assault?
Yes.
Thank you, Your Honor.
Here. He said, "Don't in the window trying to get in, but body cam, it shows the officer sitting right there with her opening door and the money. I want to whisper, we're on the record. I had run to the first time I went to the store. I was initially arrested because I had, she didn't have money. You can see. Okay, off the record. You can take her outside and ask the question. She can't whisper.
Right. I guess there's some business of in and out through the window.
Yes.
And when she entered the building through the window the first time when you were there?
So she started taking the window apart, and I think that's when they started arguing, and then she came over on the door.
Okay. You know if she actually gained entry through the window at that point?
I mean, I don't think she gained entry through the window. I think she went through the front door, but I mean, it's her residence at the same time, so.
Thank you.
Be direct.
When you made, the second time you arrived at 2301 South King, or it'd be South Martin Luther King, did you interview, I believe you said her name was Miss Lopez, or did Officer Cook?
Officer Cook did.
Okay, and did you, and after Officer Cook interviewed Miss Lopez, did you speak with Officer Cook?
Yes.
Okay, and together, I just, without telling you what she said, did Officer Cook relay to you what Miss Lopez had said?
I believe that she said strangulation.
Without telling me what Officer Cook said and what Miss Lopez told Officer Cook, did Officer Cook relay to you what she heard from Miss Lopez?
There is, Your Honor, just the statement is hearsay. I guess it can be used for its effect on the listener, but I'd ask the court not to take it as any evidence. Thank you.
I think he has corrected that already, but the objection is sustained.
So did Officer Cook simply relay to you what she learned from Miss Lopez?
Yes.
Okay, and did you relay to Officer Cook what you learned from Miss Johnson?
Yes.
And together you made the decision, you came to the conclusion that Miss Johnson was the aggressor, that's correct?
Yes.
Okay. And it was at that point that you placed Miss Johnson under arrest, correct?
Yes.
No further questions, Your Honor.
May this officer be excused?
Yes, Your Honor.
Thank you, Officer Osentoski.
Thank you, Your Honor.
You're welcome. You can go to the next witness.
People have no further witnesses, Your Honor. People rest.
Is the defense calling witnesses today?
Not today, Your Honor.
Argument?
Thank you, Your Honor. People would move that this be bound over to the circuit court as charged in the complaint. We heard testimony today from Officer Seth Osentoski from the Lansing Police Department, who said that on be the evening, well, I believe it would be the morning of July 24th, 2023. He was working as a Lansing police officer. He was dressed in full Lansing police officer uniform, driving a marked Lansing police vehicle. At that time, he and Officer Cook were dispatched to a call at 2301 South Martin Luther King Boulevard, which is located in the city of Lansing in Ingham County. It was at that point that they came into contact with an individual identified as Anaya Johnson, who Officer Osentoski positively identified here in court. Officer Osentoski testified that at the first dispatch, no one was arrested as the situation had sort of diffused itself. However, he also testified that him and Officer Cook were called back to that location for another domestic incident shortly after. After an investigation for that second domestic incident, Officer Osentoski testified that he placed Ms. Johnson under arrest. It was at this point, after he notified Ms. Johnson that she was under arrest, that she first attempted to exit the patrol vehicle, where he had to use force to keep her in the patrol vehicle. He then proceeded to speak with her through the partition. As we heard from his testimony and saw from his body cam, she managed to get one hand out of the handcuffs and get the handcuffs in front of her. At that point, Officer Osentoski notified Officer Cook of what had happened, and Officer Osentoski and Officer Cook attempted to re-handcuff Ms. Johnson. At that point, Ms. Johnson was struggling and resisting officers in their attempts to re-handcuff her. She, according to Officer Ostentowski's testimony, she attempted to grab onto the door or the cage on the door, I believe it may have been, to pull herself out of the vehicle at that point. She resisted to the point where officers had to take her to the ground, where she continued to resist Officers Ostentowski and Officer Cook. Officer Ostentowski testified that even though we could not see it on the body cam, that she was kicking her feet up at officers and that she was attempting to dig her nails into the hand of Officer Ostentowski. Officer Ostentowski and Officer Cook were eventually able to get Ms. Johnson re-handcuffed, but that Ms. Johnson refused to go back into Officer Cook's patrol vehicle, and she had to be carried, physically carried to Officer Ostentowski's vehicle. With that, Your Honor, I believe the people have met by probable cause evidence that Ms. Johnson assaulted, resisted, or obstructed both Officer Seth Ostentowski and Officer Mikhail Cook. So the people would ask you to bind over as charged on counts 1 and 2, Your Honor.
Mr. Abbott.
Thank you, Your Honor. It's the defendant's position that the arrest itself was an unlawful arrest. The fact that Ms. Johnson was the victim here of an assault and battery, not the perpetrator of an assault and battery. You can tell she's still unhappy that she feels that that's unfair. She felt it was unfair at the time she was being arrested. And I'd ask the court to consider that under these totality of circumstances, the arrest from its inception wasn't based on a valid reason.
That's not before the court. I don't know that. It's not evidence that's before the court.
Okay, then I'll take it to trial on that issue. Your Honor. But that's what brings us here today.
I don't know who was, I don't know anything about this alleged victim. I don't know, I don't have evidence before the court about the incident and who would have been at fault. That I believe was the an assault that I had before my court that was dismissed. I don't know. Was she charged with it a felonious assault?
They arrested you for.
I'm not talking to you. You have an attorney. You have the right to remain silent. Anything you say can be used against you. Was there another?
Not to my knowledge, Your Honor. I can.
She was arrested for a felonious assault and then never charged?
Again, not to my knowledge, Your Honor, but I can check.
Sounds like grounds for a motion. But I don't have that information for me as to why she was arrested. And whether the validity of that arrest can withstand these 2 counts, which is police officer assaulting, resisting, obstructing them in the performance of their duties. And so that's the issue that's before the court, not the validity of the allegation that she committed an assault. Doesn't sound like she was even charged with the assault. So if that's the truth, maybe they agreed that once they reviewed it, that she was not the subject, but should have been the victim. But I don't know that. This is all me speculating what could have happened with that case.
And, Your Honor, I don't have any way of proving it one way or the other myself. So it's their burden, however, to demonstrate that the arrest itself was lawful. All we have is the fact that testimony that the 2 officers talked among themselves and decided to arrest her. There's testimony that she's the one that sustained the injuries. So again, Your Honor, we believe that the arrest itself was not based, wasn't a good arrest.
Thank you for your argument.
Yes, Your Honor, as you stated, first of all, that whether the arrest itself was, or whether Ms. Johnson was charged with anything is not before the court. What's before the court here today is whether she assaulted, resisted, or obstructed 2 officers in the performance of their duty. We also heard testimony from Officer Ostentowski that they did their initial investigation as LPD does, and in doing their investigation, they came to the conclusion that Ms. Johnson was the aggressor and they had grounds to arrest her in this matter. And so in resisting that lawful order, that lawful arrest, I believe people have met by that probable cause evidence, counts 1 and 2, and would ask you to bind over as such.
Okay, did you ever determine if she was charged with a felonious assault with that other individual being the victim?
I do not see anything in our system, Your Honor. However, mistakes are made, but I do not see anything in our system.
Today was the date set for preliminary examination. The burden is that simply of probable cause. So the prosecutor bears that burden. They need to establish, Ms. Johnson, that there is probable cause that a crime was committed and then probable cause to charge you with the crime. This is not a trial. It's not their time to prove each element beyond a reasonable doubt. This is just more than mere suspicion that you committed that a crime was committed, and those crimes being police officer assault, resisting, obstructing. This is not probable cause as to whether or not you assaulted your girlfriend on the date in question. That is not before the court. And there was a lot of time spent on that, even on questions, and that is not before the court. We are before the court on count one, a police officer assault, resisting, obstructing, alleging that you did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Seth Osentowski as he was performing his duties. And then count two being the same, but that against Officer McCall Cook, again, that you allegedly assaulted, battered, wound, resist, obstruct, oppose, or endangered the officer in performing her duties. I heard testimony from one officer today, that was Officer Seth Osentowski. He testified that on the date of July 24th, 2023, he was in a fully marked patrol vehicle. He was wearing his full uniform. He was dispatched to the address of 2301 South King Apartment, I think 1/2 F, in the city of Lansing, Ingham County, state of Michigan, which makes a venue in this court appropriate. He stated that he was dispatched with his partner in response to a domestic assault report. He said that he spoke to both parties. Both parties were claiming assault, but neither wanted to really speak. Officers at this point determined that they just needed someone to leave. My understanding from the testimony is that Ms. Johnson was the person that was going to leave for the evening. She grabbed her stuff and left the area, or the unit. Officers then left the area. Officers then received another dispatch to that same address from the original caller, again being the alleged girlfriend of the person identified in court today as Anaya Johnson. That call stated that Ms. Johnson had broken out a window and that the girlfriend was requesting an ambulance because she had somehow cut herself. Officers arrived again to that unit. They stated they saw the defendant walking eastbound. The defendant was placed in cuffs, but at that time was not placed under arrest. This was a detainment while they investigated the incident. Officers later testified, Officer Osentowski later testified that it was determined after speaking with the alleged girlfriend / victim, if that's what we're going to call her today, Ms. Lopez, I believe her name was. After speaking with Ms. Lopez and maybe another witness, the officer determined that the officers needed to place Ms. Johnson under arrest for a felonious domestic assault. The people have admitted, People's Exhibit 1, that being the body camera of the officer Osentowski on the date and time in question. The court did see the officer advise the defendant, who was in the backseat of the patrol vehicle, that she was being placed under arrest. Officer testified that this obviously angered or upset the defendant. That could be seen on the body cam. Defendant was very upset and was adamant that she was in fact the victim. She was adamant that she was assaulted first, and that the person, Ms. Lopez, was not in fact the victim. The officers testified that Officer Osentowski testified that he later noticed that first he said that the defendant tried to get out of the patrol vehicle, so that he can speak to Ms. Lopez. He advised that she could not get out of the vehicle. The video for the body cam did show or demonstrate what appeared to be Ms. Johnson trying to exit the patrol vehicle. Officers having some level of struggle to close the door to keep her in there. Ms. Johnson, inside of the patrol vehicle, was later heard banging or doing something within the back of the vehicle. Officers Ostentasi testified that he visualized Ms. Johnson banging her hands up against the back of the patrol vehicle, the partition that's inside of the patrol vehicle, and that caused him to be alert because her hands were in front of her. When she would have been cuffed, those hands would have been behind her. He flashed his flashlight. He shined his flashlight, noticing that one of her cuffs was off. The video did visualize the officer informing his partner, Officer Cook, that the cuff, which he believed was the right wrist cuff, was no longer on the subject's hand. And so officers came to attempt to try to resecure Ms. Johnson to take her down to police on the alleged charges of felonious assault, at which time the testimony of Officer Ostentasi was that the defendant, Ms. Johnson, was assaultive and or resisting their ability to secure her in cuffs and take her into custody. There was video that showed a scuffle, some back and forth, officers having to, I think, push or pull her out of the back seat of a vehicle and having to get her down to the ground to try to get cuffs on. Whether or not there is or was a lawful arrest or believed to have been, officers believe they had reason to arrest the defendant on a felonious assault, is not before the court to decide today. That's a matter that your attorney could brief properly before the circuit court on a motion to dismiss. Before the court today is probable cause as to count 1 assault, police officer assault, resisting, obstructing, and count 2 police officer assaulting, resisting, obstructing. The court is satisfied based on the evidence submitted today that there is sufficient probable cause to support both of those counts. Those counts will be bound over to the circuit court for a bind over date of October 25th. October 25th is not a court date for you, Ms. Johnson. It's the date that the circuit court gets the file from the district court, okay? Your next court date in this circuit court will be a pretrial. Mr. Abbott will be made aware of that date. Do you have any questions for me at this time?
No, thank you.
Okay. Bond was set at 1,000 personal recognizance. That will continue. Any additional matters for today's record?
Nothing from the people, Your Honor.
Not from the defense, thank you.
You're all set. Good luck to you, ma'am.
$10,000 bond.
Mr. Abbott.
Yes, Your Honor.
We're continuing on Cowden.
Yes.
I don't know. Did you get my email last night? I did want to go briefly on the record for the PCC, Your Honor.
Okay. Is he gonna be logged on? Is that someone?
I believe that's him.
That's what I was wondering.
And then I'd like to speak to Mr. Coyle.
Who was in the jail?
Zachary Cotton, Your Honor.
You ready to go on the record?
Yes, Your Honor.
Yes, Your Honor.
Hi, friends. On the record in the matter of the people of the state of Michigan versus Zachary Edwin Cowden, file number 23-02982. Appearance, please.
Jeff Prados on behalf of the people, Your Honor.
Good afternoon, Your Honor. John Abbott representing Mr. Cowden. He appears by video from the jail.
Today's the date and the time that's set for probable cause conference. This matter is scheduled for preliminary examination October 19, 2023 at 9 o'clock in the morning in person before the court. How are we proceeding?
Yes, Your Honor, I believe at this time, Mr. Abbott would like to lead this on preliminary examination, as with the people. However, the people would ask the court or would like to ask the court to suspend Mr. Cowden's communication privileges at this time. The people, in reviewing jail calls from Mr. Cowden's account at the jail, have found at least one jail call where he is in contact with one of the listed victims in the complaint. That being, I believe, a Miss Kylie Mole, I believe is who it is, the victim of the assault and battery. And in said phone call, he specifically instructs Miss Mole as to what she needs to come to court to testify to. So at this time, the people would ask that his phone privileges or his communication privileges be suspended, Your Honor.
Thank you, Your Honor. As far as it goes, yes, we do want to continue examination on this charge, Your Honor. I have received some of the phone calls that the prosecutor alludes to. I'm not sure if you can demonstrate exactly who's on either end of the call. I'll leave that to the court's discretion.
Okay, so what we have here is an allegation of a bond violation, Mr. Cowden. So the prosecutor is alleging that you violated your bond by making a phone call to a victim or alleged victim that you were not supposed to be in contact with.
I checked, and I wanted to make sure, just to clarify for the record, before I made that motion, that I looked at the bond motion, the bond that was filed in this. The victim in this matter that he has been speaking to is not listed specifically on the bond motion, as he is not allowed to have contact with her. However, I believe the contact that he did have in the phone call that was
the alleged contact with?
Miss Kylie Mole, I believe is the name.
Her name is on this PA 53 form.
But I believe not. I believe under the threatening, intimidating, and the can't have physical contact with, but I believe the I believe I saw the communication. She was not listed on there, Your Honor.
Okay, I see Mackenzie Melton on do not harass assault. No, on S, and he was arraigned by Magistrate Sidney Faulkner. She clearly advised him, right? I could pull the record, that she put on my ROA that he did not have contact with Mackenzie Melton or Kylie Mall. That's on my that's on my ROA. So that means she advised him of that.
Okay.
I think, and I could be wrong, that she probably didn't put it on here when she put those names 3 letters in a row, R, S, and T. I only see Mackenzie Melton. But I have reason to believe that he was advised that he's not to have contact directly or indirectly during his arraignment, because that's what she wrote on this ROA here.
Your Honor, are we to understand then that there's actually no written order that he's violated?
There's no record here that he's violated by making or having direct or indirect contact with, if it's Kylie Mole, because the allegation here is that he was on the phone or talking to a Kylie Mole.
Yes.
I'm looking at the Magistrate Faulkner's PA 53. It says, do not assault, harass, intimidate, beat, molest, wound, or threaten Mackenzie Melton or Kylie Mole. Under do not have or cause any third party for contact, it does not have Kylie Mole on there.
And that, Your Honor, it's not the people's request is not based on a violation of the PA 53 of specifically no contact. It is based on the fact that in reviewing the calls made from the jail, that one of the said calls between the account of Mr. Zachary Cowden and the number that is listed on the police report for Ms. Kylie Mole has the individual from the jail, and for the record, we do have a detective assigned and looking into this, but has the individual on that account talking to the number associated with Ms. Kylie Mole, giving her specific instructions as to what to come to court to testify to, Your Honor.
Okay, this is a witness of yours?
Yeah, this would be a potential witness.
So the allegation is witness tampering or intimidation?
It would be witness interference, but
or
yes,
witness
Your Honor.
interference, because A, the first request should have been a request to amend the bond. If you notice that that's a violation, before you ask me to remove his phone privileges for something that's not on order. It's not on order. I'm not removing his phone privileges because it was not on an order. Now, if you want me to amend the bond, I'll
Yes,
listen to your
Honor.
motion.
The people would ask that you amend the bond as well, so that to include Ms. Mill on there, as the court also indicated, that seems to have been the intention of the magistrate as well at that time.
I can only assume because that's what she wrote here, but that's not what's in the order. And so the court speaks through orders, and the order does not state that he can't have contact directly or indirectly with Kylie Mall. And so I can't penalize him by taking away a privilege on something that he wasn't properly ordered not to do. But I can now reorder him. I'm going to amend the bond, sir. Your bond includes all of the things previously stated to you at the time of your arraignment. However, it also now includes you're not to have contact directly or indirectly with Kylie Mole. Do you understand that?
Yes, Your Honor, but she's my fiance, soon to be wife.
I don't care who she is. I don't care if she's your mom. I don't care who she is. Do you care what the order was?
No contact.
Thank you. And so, and as you are or should be aware, the Ingham County Prosecutor's Office makes time to listen to phone calls. And you should also understand that if you try to use someone else's number to call, they listen to those too. Okay?
Yes, ma'am.
Okay. So I'm not going to revoke your privileges to use the phone right now, primarily because there was an error by the court when the magistrate arraigned you, and I don't see where she put that in the order. And so it's now going to be a part of the order. Any violation or allegation that you violated will result in your bond being both revoked and pending a hearing on the bond violation, and your privileges for calls while in the jail will be revoked as well. Do you understand that?
Yes, Your Honor.
Okay, and so we're going to continue to exam next week, correct?
Yes, Your Honor.
Okay, any additional matters for the record today?
Nothing from the people, Your Honor.
Not for the defense, thank you.
Okay, you're all set, sir. Oh.
Is there anyone that I can speak to my lawyer?
You want to talk to your lawyer?
Yes, ma'am.
Give me just a moment. I'm going to put him in a private meeting room.
Thank you, Your Honor.
Do you want to log in and speak to him?
Thank you, Your Honor.
Thank you. And then as luck would have it, Kylie Mull is in my waiting room. Was she requested to be here today for some reason?
No, Your Honor. Can I speak with Mr. Coyle briefly?
Jason Linton should be showing up.
I'm sorry? You have to really put him in the room. I'm sorry, she's asking me. Oh, no, I'm trying to figure out why she's not starting her audio.
I'm
Kylie
Anna.
Mull,
Yes.
how can I help you?
Hi. I was wondering why there would be a no contact between me and my fiance.
Oh, you should call the prosecutor and talk to him, okay?
Okay, because he.
Okay, You call the prosecutor's office and talk to the prosecutor, okay?
Okay, thank you.
Thank you.
Russell, Madam Clerk, is it possible for you to put Mr. Dawson and I in a breakout room? Jeff, do you know if we even need to go on the record? Courtroom's muted.
Are we still just leaving it on for prelim, Mr. Coyle?
Yes,
Okay,
and I will
then
let you know.
that's up to the judge. At that point,
What's up to the judge?
go on the record or not.
Oh, okay.
Well, you go on the
Yep,
record.
I'm in no hurry. We'll wait, for sure.
Do you know where Miss Donnelly is? Do we know where Miss Donnelly is with Clark? Yeah.
Donnelly's in her office. She was just talking to Mr. Meyer. You gotta take that off.
I'm sorry about
She was just talking to whom?
Mr. Myers here.
Oh, Miss Donnelly is here, okay. On the record, in the matter of the people of the state of Michigan versus Russell Dawson, file number 23-02744 FY, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
And good afternoon, Your Honor. Christopher Coyle appearing on behalf of Russell Dawson. My P number is 49708. Mr. Dawson is here by way of Zoom. Mr. Dawson, can you state your name for the record, please?
Russell Dawson.
Okay, today's the date that's set for a probable cause conference. I set the matter for preliminary examination November 3rd at 8 o'clock in the morning. Are we continuing to an exam on this?
Yes, Your Honor. There has been discussions between the prosecutor's office and Mr. Coyle. There is a new offer on the table, and that would be for Mr. Dawson to plead to a misdemeanor assault and battery in this matter. I believe Mr. Coyle would like some time to discuss that with his client, so we were leaving it on for preliminary exam.
Okay, so we'll.
That's correct, Your
continue
Honor.
to exam at this time. Bond was set at 2,000 personal recognizance. Do we need to address bond conditions at this time at all, council?
No, Your Honor.
Okay, bond will continue as set. Any additional matters for the record?
Nothing from the people, Your Honor.
Not on behalf of the defense. Thank
Okay,
you.
you're all set.
Thank you.
Thank you.
You're welcome.
Leave.
Yes. Ms. Donnelly, you're here with Mr. Myers.
Yes, Your Honor.
Okay, on the record in the matter of the people of the state of Michigan versus Maurice Antoine Myers. File number is 23-02984 FY, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
An Assistant Public Defender, Sarah Donnelly, on behalf of the defendant who is appearing in person.
Okay, Mr. Myers, today is the date that's set for a probable cause conference. On one count of assault with a dangerous weapon. This matter is scheduled for examination October 19th at 8:30 in the morning in person at the court. How are we proceeding, counsel?
Your Honor, at
People
this,
would defer-
oh, go ahead. Go ahead.
People would defer to Donnelly, Your Honor.
Okay.
Ms. Donnelly?
Yes, we would like to continue under preliminary exam. There has been an offer from the prosecutor to plead to, believe it was added counts, count 2 and 3, separate assault and batteries, and they would dismiss count 1. We would like this continued on to preliminary exam at this time. Mr. Myers he needs to report to pretrial services still. I was hoping that maybe there was, he didn't have something to write with. If they have the pamphlet or something that he could write down the number on at least, so that he could, or and the address. Well, he knows where to go over there, but just in case he needs a number, he does need to report. Thank you, Your Honor.
Sounds good. Okay, so bond was set at 2,000 personal recognizance. That will continue. We're providing you with additional information as to how you need to report to pretrial services, which is one of your bond conditions. Do you have any questions right now?
Yes, we should put the pretrial services.
Pretrial services, yes. That's what that information is in your hand.
So we have to go on to the.
There should be a contact information where you can go to pretrial services, which is over in the circuit court building.
I'm a little confused. You have to go to the circuit court building and report there.
What does that paperwork say as to how to you report? Gives you options.
I'm going with you right now.
So you're gonna go straight there and say, okay, very good, because you were arraigned on the 29th. You were supposed to report within 48 hours. Did you do that?
I had a warrant, I was in Clinton County.
Okay, so you were just released from
Yeah.
Clinton County? Okay, so then you need to report. You should do that immediately, okay? Okay, do you have any questions? You're all set. Thank you. They didn't put Mr. Clark on yet, so.
I see that, Your Honor.
Is Asia Williams present?
Your Honor, I have not been able to get in contact with Mr. Williams.
Or Isa Williams? Okay. I'll issue a bench warrant. Okay, Crystal Bolden,
Yes,
okay, do you have an attorney?
yes, David Carter.
It's not on my document sheet.
Yes, actually. Yeah, but Melanie.
He's not filing an appearance.
Right.
Your Honor, Mr. Carter has filed an appearance with our office. We spoke about this PCC yesterday via email. He did confirm he'd be appearing via Zoom. I'm here on behalf of the people.
Okay, sounds good. Well, we're waiting for him to appear.
Sounds great. Thank you, Your Honor.
Thank you. There he is. Mr. Carter,
Yeah,
you're representing Ms. Golden, correct?
that is correct, Your Honor.
Did you file your appearance with the court? Because I don't have one on my file.
Did I send an appearance to the court? I believe I did. If not, I can make sure I email it to you right after the hearing.
Sounds good. Did you need to meet with the prosecutor, or are we ready to go on the record?
We're ready to go on the record. This will be proceeding to a preliminary exam, but I wanted to address bond.
Okay, on the record, in the matter of the people of the state of Michigan versus Crystal Bolden, file number 23-02912 FY, appearance, please.
Good afternoon, Your Honor. Assistant Prosecuting Attorney Melanie Smith on behalf of the people.
May it please the court, David B. Carter Jr. on behalf of Ms. Bolden, who is present and is appearing by Zoom and would waive her personal appearance.
Okay, today was the date and the time set for probable cause conference. The matter is scheduled for preliminary examination October 19th at 9 o'clock in the morning on one count of interfering with the crime report. We're going to continue to exam, that's correct?
That is correct, Your Honor.
Okay, and you wanted to address bond? You can do
I
so at
did.
this time.
Thank you, Your Honor. Your Honor, I also requested someone from
They're
DHS.
present.
Yes, and I wanted to acknowledge that that's the supervisor for my client's case. At the arraignment, which I was not available to attend because I was in a murder trial, the magistrate instructed that there'd be no contact with the minor child regarding this incident. And I have great concerns that that was done to be vindictive and to try to conquer and divide this family. I would like to draw to the court's attention that this case, the alleged facts of this case occurred on December 9th of 2022. That's nearly 10 months ago. And the charges weren't authorized until September 18th of 2023. If there was concerns regarding this child's safety, why in the world did they wait over 10 months to charge this case? Not only that, the DHHS is here and can testify that back in December of 2022, my clients voluntarily started with services with them and have continued to work on services throughout this whole thing. My client was getting frustrated because she was working with DHHS with no end in sight. Matter of fact, she contacted her then caseworker regarding the criminal charges in this and said, please contact the detective and find out what's going on in here. When my client started to do that, then somehow there was an anonymous tip or complaint that a child was being beaten inside the home, and the detective and then a short-term caseworker came out to the house to investigate this. Nothing was substantiated. We believe that the caseworker at that time was acting outside her scope of helping this family and was acting in a vindictive manner. And then all of a sudden these charges have come about. My client has taken her child to the doctor. My client has allowed CPS to talk with these children alone, and none of them have issues with abuse in the home. It's my understanding that the family has a safety plan in place, and I truly can't believe that after 10 months that the magistrate has chose to use a no contact with the family. I think it's detrimental, and I'd ask the court to lift the no contact. And again, DHHS supervisor is here at the hearing and can be sworn and can be asked questions.
Thank you. Ms. Smith?
Thank you, Your Honor. I think the no contact order is appropriate given the nature of the charges. We have here a very young child who, based on the allegations, is being coached to not provide information to any investigative authorities, substantially interfering in both police and the prosecutor's ability to investigate the co-defendant that's charged in this matter's conduct with the child. So I think it's appropriate. I would ask that you maintain it at this time, especially since we are just pending a preliminary examination next week. The court could hear evidence at that time and readdress this in just a week. I think that would be a more appropriate time. Thank you, Your Honor.
Okay, so what you're saying is that there is a co-defendant in this matter, correct?
That's correct, Your Honor.
And that you have the understanding or information that would support your position that this defendant has been interfering with the law enforcement's ability to investigate and prosecute this?
That's correct, Your Honor. That's the nature of the charge. The child disclosed that he was directed that we don't talk about these types of things. This is family business, things of that nature. That's the basis of the charge that Your Honor will hear more evidence about next week.
Okay.
And Your Honor, I'd like to respond to that briefly.
Yes, you may.
Thank you, Your Honor. This alleged comment by this child happened one time back in December. And if the prosecutor had issues with this, they would have charged this case a lot sooner, not wait 10 months. There's been no allegations. I've read through the police report, looked at the videos. There's no allegations since December that this family has tried to manipulate this child. Second of all, the co-defendant is not in the home. The one that has the more egregious conduct, the ones I believe he's being charged with child abuse. He's not inside the home. I believe that this is detrimental to the family unit, and I believe the DHS worker can testify to that.
Your Honor, the child is placed with a family member, I believe the defendant's mother. And with respect to the delay in charges, Mr. Carter's been doing this a long time. We all know that there are various reasons for delays in charging decisions, and you can shake your head all you want, Mr. Carter, but that's
Well, not for something supposedly harming a child for 10 months.
When she,
Come on.
Mr. Carter, when you spoke, she was quiet.
Well, she addressed me by shaking my head, so I responded.
I'm all set, Your Honor. Thank you.
Thank you. Thank you. Now the issue I have is not necessarily that there's an age of the case, because again, we all know that there's different reasons why it takes so long for things to be investigated or charged. This is a matter with an alleged date of offense of December 9th, 2022. But the mere nature of the actual allegation is one count of interfering with a crime report, alleging that your client has taken some actions or did attempt to take some action against this individual, that individual being her child, to prevent them from reporting or attempting to report a crime of an assault. I'm not clear at this time as to why the minor is not in the custody and care of Ms. Bolden. I don't know if that's due to this pending case or if it's a matter that is in the family court. But I think that it's appropriate, and I think you are well aware that it's common that we issue a no contact order when we have these types of cases, because of the delicate nature of making sure that there's no coaching, there's no interference with testimony. And by the mere allegation being brought forth, there's allegation of already interference. So at this point, the court's going to deny your motion. We're going to continue to exam next week. You can rebring your motion to amend the bond at that time.
Thank you.
Thank you. Any additional matters for today's record?
Nothing from the people. Thank you, Your Honor.
Nothing for the defense.
Thank you. You're all set. Is he waiting for somebody? Mr. Cowden, are you waiting for somebody?
We're waiting for the court, Your Honor.
Okay. We already did this one. I'm confused.
I apologize for the confusion, Your Honor. Mr. Cowden asked me to raise an issue with the court regarding his personal health there in the jail. He's
Okay, well, I gotta call the case again then.
okay, thank you.
No problem. Ms. Bolden, you're free to go. Your attorney is logged off. You have Mr. Linton here as well. Mr. Abbott, did you want to go on the record for that, or are we continuing?
I guess I'd like to speak with him briefly if I get in a breakout room once we get through this, please.
Okay, I'll put you, you can go back into your breakout room and I'll add him to your breakout room.
Okay, are we going to deal with Cowden first?
No, we're gonna deal with the PCCs first.
Okay, thank you.
Thank you. Okay, and did we see Brandon Williams? Let's continue. You're already in the room, Mr. Abbott. You just need to return to room 4. And then Mr. Feigelson has one. And is that all I'm waiting for? They never put, oh, is he holding up Miss Donnelly's ability to have hers? Is that what's going on? That's probably what's
I don't think so, Your Honor. He was supposed to be in a different Polycom room.
Unbelievable. Well, we tried to email, they haven't responded either, so. Person.
Your Honor, I was able to get a hold of post 2. They said he was in the room, but they didn't realize that it hadn't logged in yet.
Wonderful, thank you. Okay, on the record, in the matter of the people of the state of Michigan versus Jason Linton. And this is in file number 23-02876, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good afternoon, Your Honor. John Abbott representing Mr. Linton. He's appearing by video from Turning Point Rehab Center.
Okay, and Mr. Linton, this is your probable cause conference. I have one count of controlled substance. Possession, and count 2 of controlled substance possession as well, with habitual offender 4th offense notice. These matters are scheduled for preliminary examination next week on the 19th at 9 o'clock in the morning. Are we continuing to examination, Mr. Abbott?
Not at this point, Your Honor. I think Mr. Linton is going to be I'd like him to be evaluated for substance abuse specialty court. That would require a waiving of the 21-day rule. Or is that what's?
Okay. That's correct. So, Mr. Linton, you're going to be screened, it looks like, or you would like to be screened to participate in the specialty court. Is that accurate?
Yes, ma'am.
Okay, so you have the right to have a preliminary examination in this matter within 21 days of your arraignment. Because it takes time to do the screening, we would not be able to have that within 21 days. So are you willing to waive the timeline so we can reset this?
Yes, Your Honor.
Okay, anybody threatening you to get you to waive that timeline?
No, Your Honor.
Okay, we'll get you a new date, and then that way you can undergo your screening to see if you're eligible to participate in the specialty court.
Yes, Your Honor. Thank you.
Yes, please. Yes, please. November 16th at 8:30 will be the new probable cause conference. We'll set up a new preliminary examination on that date if necessary, okay?
Yes, Your Honor.
Bond is 4,000 personal recognizance that will continue. Any additional matters for the record?
Nothing from the people, Your Honor.
Not, thank you.
Okay, you're all set.
Thank you, Your Honor.
November
16th at 8:30.
Okay.
Back on the record in the matter of the people of the state of Michigan versus Zachary Cowden and file number 23-02982. Mr. Abbott, you requested to go back on the record on this.
Yes, I have, and thank you very much, Your Honor, for indulging me on this issue. Mr. Cowden has suffered injury to his leg. I think he got hit by a car. He's got the steel pins and rods and plates holding his leg together. There may have been some inappropriate, rough behavior when he was arrested that exacerbated the injury, and now he's worried that the screws and pins are loose. And he's lost, he's really losing his ability to use his leg. It's getting worse instead of better. He's apparently supposed to be in a recuperating situation, and he's not in that right now. He's also on, we've got a bond hearing next week, Your Honor, since this new charge is the allegation of a violation of bond on 23-1265 FY. Both of those are scheduled for next week. What I'm requesting, Your Honor, is two things. One, if he could be granted a bond on the other case where his bond is revoked due to the bond violation, so that he could be seen by a doctor of his, so he could get out of jail and be seen by a doctor. And absent that, Your Honor, I'd ask the court to, I've sent an email to Captain of the jail. I've contacted the jail regarding this, received no response yet. And so he hasn't been seen at all by anybody, any doctor or nurse since he's been there. So that's the situation, Your Honor. His condition of his leg is deteriorating. He'd like to get out and see a physician. Thank you.
Okay. Did he hike medical?
Yes.
Okay, when did he do that?
I'm not sure.
What was that?
When did you kite?
I kind of medical twice now. When they first had me come to jail, they had me on a withdrawal check for the first 3 days. I've let every nurse and everybody in the jail know my condition of my leg. I was supposed to see the physician or doctor or whoever Tuesday. Nobody ever came to call me out to see me. Since I've been in here, I don't have very big hands. My thigh, I can put both my hands around my thigh and touch my fingertips together. And due to my accident, I have 3 screws, 2 rods, pins and plates in multiple places in my left leg, holding it together. And I was supposed to start physical therapy sometime this month. And then due to me being in here, I'm actually not able to rotate my ankle like I was before I was arrested. I have 4 pins and a plate poking out of my shin. And I've asked medical multiple times to take a look at it. I'm not asking for, anything else to be able to heal properly. I understand that I missed court last time, and that was due to another accident that caused injury to my right leg. But since being here, I'm not actually able to bend my leg how I'm supposed to. I have minimal movement in my knee now, and that was fully reconstructed by the doctors in Grand Rapids.
Okay, I do have his other file that he was remanded on. Not only is there a failure to continue his, is this someone who cut off his GPS? Yeah, he was on GPS tether and he cut off his GPS tether. There's 3 bond violations in this file. It's not getting a bond. It's not happening. He doesn't follow bond. He doesn't follow bond. He doesn't follow bond. This is not negotiation. We're not going back and forth. You have completely disregarded bond. 3 times you cut off a tether. And no, put your hand down, because your attorney made a motion and didn't even address it. So the bond on that is gonna be denied until that, and we can review bond after your hearing. We're not gonna keep looking for you every few months because you don't wanna come to court. There, I have a domestic violence third offense notice here in assault and battery. Bond extremely reasonable, 5,000, 10%. So that's not even something that needs to be amended because it's a low bond considering the allegations that are being alleged. And so if he wanted to post that bond, or if he had posted that bond, then we could even probably address this. He can get medical attention without getting a bond.
Your Honor, the tether was cut off due to an accident. Due to my bike accident back in May was the reason my tether was cut off.
And who did you notify that your tether was cut off because of that?
I couldn't notify nobody because I was in a coma for a month and a half. By the time
Okay,
that I came
you
out
were
of
in
my
a,
coma-
you were in a, excuse me? Excuse?
By the time that I came out of my coma,
One,
it was-
off the record, off the record.
I really hope that's not Asa Williams.
Right, that's all I can gather. Or am I wrong to assume that?
I mean, he was supposed to show up at 1, so.
We're having an issue. Give me just a moment.
Yes,
I can
Judge.
hear it, Your Honor. Thank you.
Yeah, I'm still there.
Yeah, we're still on. There was just a little disturbance, but it's over.
Okay. Um. So we're gonna have to wait till the 19th then, huh?
Yeah, we'll be here on the 19th.
Because I mean, the reason I didn't let anybody know about the accident and everything like that was because I didn't remember anything.
Yeah.
I
In a coma.
I had to be told about my accident. I had to be told who I was. I didn't remember anything. I got, I got a scar right here, John, from when they stapled my head back together because I had hit my head so hard. I had 13 staples put in my head. I didn't remember that I had court cases going on. I didn't remember who I was. I didn't know nothing. I was told all about this. I was told about my accident. I was told about everything. I I don't remember anything. I don't even remember my birth. I didn't even know my birthday. Like from May 26th to July 4th, I don't remember anything. So
Abbott, did you see my text message?
Yeah, I'm not sure who Asia Williams is.
Oh, they didn't identify him? Okay.
It tased him twice or 3 times.
The thing is, my guy who was supposed to be here at 1, he kind of tends to do those things, so I'm worried.
He was in Flores' court.
Okay. I swear.
John, did you get my X-rays and everything?
What's that?
Did you get my X-rays and everything?
No, I don't have your x-rays.
You didn't get them. You didn't get my X-rays. You didn't see.
Nope.
Patty, I'll take it that there's no one in the waiting room from the jail yet. If they're not here yet, I'm just assuming.
There's a couple of people in the jail. Yes, there's some people in the jail. I'm about to admit them now. Mr. Cowden said you're gonna see or back on the record. Mr. Cowden, you're supposed to see a medical professional next week, correct?
Yes, Your Honor.
Okay, and that's at Ingham County Jail, or are they taking him to Spiro?
I haven't heard any response from Captain.
It's a MSU sports training and medicine.
Oh, it's a personal appointment that you have?
Yes, it's to check out my recovery and to do my to start my physical therapy.
Okay, you have not heard from Captain Earl yet? You said,
I have not.
when did you reach out to him?
Wednesday.
Okay, let us do this. Let's follow up with Captain Earl and or Major Southworth. And then we will address this Monday morning.
Thank you.
Okay, Mr. Cowden, we'll address your bond on that file on Monday morning. I'm denying the amendment of bond on the other case because it's already reasonable. But we'll address the bond on 23-012-65 after we hear back from the jail to see what kind of medical assistance is being rendered from Ingham County Jail, okay?
Thank you, Your Honor.
Okay, you're all set for today. Who's representing Clark? Is that Michelson?
Donnelly.
Oh, Ms. Donnelly, did you need to speak to Mr. Clark?
Yes, Your Honor.
Okay. Mr. Feigelson, are you ready to go with your client?
Your Honor, if I could have a quick background as well, that'd be great, please.
Okay.
Thank you, Your
sounds
Honor.
good.
Hey, Judge. They never sent Mr. Pearson into the breakout room.
Oh, okay, give me one moment.
Yeah, thanks, Your Honor. Judge, you can bring Mr. Pearson back, please, Your Honor.
No,
Okay, sounds good.
Thank you, Judge.
Okay, Mr. Feigelson, are we continuing or do we need to go on the record?
We need to go on the record, Your Honor. Mr. Pearson wishes to waive his preliminary exam this afternoon.
On the record in the matter of the people of the state of Michigan versus Thomas Person, file number 23-03052, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good afternoon, Your Honor. Assistant Public Defender Stephen Feigelson. Appearing on behalf of Thomas Pearson, who's also present by way of Polycom this afternoon from the Ingham County Jail.
Okay, is it Pearson or Person?
Person.
Okay, thank you. Today's the date and the time that's set for a probable cause conference, and you wish to unconditionally waive examination, is that accurate?
Yes, ma'am.
Is there an offer on this?
There was no offer at this time, Your Honor. Any offer could be negotiated up in circuit court.
Okay, so the people are waiving their exam.
Yes, Your Honor, the people would also unconditionally waive their preliminary exam and ask and move that this be found over as charged.
Okay, so you have the right, sir, to have a preliminary examination here in the district court. At the time of your preliminary examination, Mr. Person, you have the right to require the prosecution to put forth evidence to establish they have sufficient probable cause that a crime was committed, and then sufficient probable cause to charge you with the crime. You wish to unconditionally waive that right today?
Yes, ma'am.
And you understand that you can't later return and decide that you want to have your exam. Once you waive it, the matter is bound over and you must proceed to the circuit court. You understand that? Do you understand that, sir?
Yes, ma'am.
Okay. Anybody making any threats to you to get you to waive your preliminary examination?
Ma'am.
I didn't hear your answer.
No, ma'am.
Okay. Any promises being made in exchange for you entering a waiver today?
No, ma'am.
Okay. Your bind over date's gonna be October 25th. That's the date the circuit court gets the file from the district court. You don't need to appear in court on that date, okay? A bond was set at 25,000 cash surety that will continue any additional matters for the record.
Nothing from the people, Your Honor.
Judge, may we address bond?
You may.
Your Honor, bond is presently set, as the court indicated, 25,000 cash as surety, Your Honor. I don't think Mr. Pearson is able to post that, Your Honor. He does have a probation hold. I think that'll get lifted on Monday with Judge Dragonchuck in the 30th Circuit. He is working. He always has appeared for court. I'd ask for a reduction of bond this afternoon, Your Honor.
He's on probation?
Yes, he is.
Not provoked, okay. And there was a no bond hold out of the
Correct.
circuit court?
Yeah, that should be lifted Monday, Your Honor. He has his probation violation arraignment in front of Judge Dragonchuck on Monday.
Okay, it's not with Judge Kennedy?
It is not, Your Honor. I think this was one of the cases that got transferred to Judge
Okay.
Dragonchuck when.
That's what my report states here, okay. Did the prosecution want to address bond?
Just briefly, Your Honor, if people would object to a reduction in bond in this, this is Mr. Person's second time, at least in the last 2 years, as far as I can tell, where he's been caught with a firearm without a license to carry. I believe the first time, which is what he would be on probation for with Judge Dragonchuk, was originally charged, I believe, as a carrying a concealed weapon, but then was pled down to a possession of a loaded firearm in a vehicle. And so this is, as I stated, the second time in at least 2 years that Mr. Person has been caught with a concealed weapon on his person, Your Honor.
Okay, so we have one count of carrying concealed weapon, maximum penalty 5 years and/or $2,500 in fines and a mandatory forfeiture of the weapon or device required under the law. I don't have anything other than this report from pretrial services, which does not indicate that he has a history of failing to appear, or at least not 2 or more failure to appears. Okay, so it says he does not have 2 or more prior qualifying failure to appears to assess as a risk factor. And then this is not a case that was charged that there was some allegations of violence using a firearm. It was charged as just possession of a firearm. Allegation being that it was, I guess, in plain view when he was taken into custody. I think $25,000 is a bit steep based on the charges, even the maximum penalty in this charge. I'm going to amend the bond. It won't be personal recognizance, but I will amend the bond to 7,500 cash surety. All other bond conditions will continue.
Thank you, Your Honor.
Any additional matters for the record?
None, Your Honor. Thank you.
Thank you. You're all set.
Take care, Mr. Pearson. Peace. We'll see you on Monday.
Okay, thank you.
Yeah.
Mr.
Oh, Ms. Donnelly was in.
Yeah.
Got it. Are you ready, Ms. Donnelly?
Yes, Your Honor.
Okay, on the record. Thank you. Thank you. On the record, in the matter of the people of the state of Michigan versus Brandon, I'm sorry, this is not Brandon Williams, this is Ms. Donnelly's. Darren Clark. This is Darren Clark, file number 23-03033 FY. Council appearance.
Jeff Radowitz on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Darren Clark, who is appearing separately from the Union County Jail.
Okay, Mr. Clark, today was the date that was set for your probable cause conference. You do have an exam scheduled on the 19th at 8:30 in the morning. Are we continuing to examine Ms. Donnelly?
Yes, Your Honor, there was an offer from the prosecutor. At this time, Mr. Clark is considering it as we set this for exam next week.
Very good. Okay, I'll note here that we are going to continue while he considers the offer. And he is in Ingham County Jail at this time, is that correct? Yeah.
He is, Your Honor.
Okay.
So I was going to make a bond request.
Okay, I was gonna say bond was set at 5,000 cash surety. You can address bond.
Thank you, Your Honor. Mr. Clark also has, well, he was on probation in Battle Creek in Calhoun County, which I believe is one of the reasons why he did not get a personal cognizance bond on this. We will be requesting that it be converted to a PR or a 10% to give him the opportunity to post bond. He has not been able to post the 5,000 cash surety at this moment. He's largely homeless, though he was before he was arrested working with a group out of a church to find a place and get a job. So he believes that would still be available to him if he was released. Otherwise, he does have to he would be having to go to Calhoun County to take care of that matter anyways first, Your Honor. So that's reasons why I'd be requesting either a 10% or a PR. Thank you.
So if he PRs, he has a hold or something going on in Calhoun?
He was on probation in Calhoun County. It's a violation and warrant that's holding him.
That was my understanding, and we can't afford to move him from this case at this point because we can't rid him from Calhoun or next week if he leaves.
I understand, Your Honor.
So I'm not inclined to amend his bond at this time. It's set at 5,000 cash surety, which is reasonable under the circumstances. I'll address bond again if you'd like next week after his exam.
Thank you, Your Honor.
Additional matters for today's record?
Nothing from the people, Your Honor.
Nothing for defense.
You're all set. Thank you.